We're good.
You good? Okay, you got the cases I sent?
Sure did. Ms. Archer and all want to see I ain't had a chance to look at them yet. I mean, I saw them, but
That's all right. That's all right. You'll have chance.
yeah, I just scanned through the titles.
Yeah, I just want to
I
make
was,
sure you got them.
all right, yes,
Yeah.
ma'am.
Okay, all right. Because I'll be sending some.
You said just now?
No, I said I will be sending some more.
Man, I thought that's what I did here.
Yeah, no, you heard right. You heard right. Because the case law shows you how the law itself is applied. I don't know if when you began, it was made clear to you that you have the legislation, you have common law cases, and then you have to understand how the law is interpreted. So it's clear. You can't just lift it out and say, this is what it means.
Okay.
Okay, all right. I hear the people coming in and out, but that's more. Okay, so what you need for today is chapter module 7. I need you to pull up on your screen the amendment to the Employment Act 2017. So, the Bahamas. To Alpha if you don't have it already, and go down to the Employment Act Amendment. And you should be able, let me know when you found it.
Yeah. This is up there. I just need to be present in this class.
Where were we supposed to look once we found the 2017 act?
Okay, you found it?
Yeah, I have a copy. I didn't get which page you said we needed to look at.
All of it.
Oh, okay.
Yeah, all of it is practically all of it relevant for.
Are you spelling your name? In 1 second, for me, I'll reprint it. Sign on top of your name. Also, the co-star, in order for us to hand over your final payroll, we have an exit advice form for you to fill out, okay? Once you do that and submit that, then the ticket is booked. And then you can have your, whatever funds you may have worked for. There'll be your salary card along with any vacation balance you may have left today. Keep in mind that you will be removed from company insurance as well in 1 week's time, okay?
Right, so we ready? Let me know if you've located it. Go to laws of Bahamas, go to alphabetical, click on E and go to employment.
Say what?
Laws of Bahamas.
Excuse me, exit advice forms are there.
Hold on. Hey. Confused.
And I'm just the form.
Yes.
Morning, Miss Acha.
Good morning.
Morning, everyone.
Just do everybody have the amendment to the Employment Act?
The 2017, right?
Yes.
Okay, number one,
Yes.
please. 512.
I don't have why.
Okay, so let's start. Before got your results, right? The midterm?
Yes, I got
say-
mine.
Oh, I didn't get any.
No, the
Who was supposed
results.
to send them out?
Miss Dean.
Oh,
Miss Dean
gosh.
did.
Oh, I didn't get it. I probably got to follow up again with the same email issues. I guess they never changed it in the system.
Oh, okay. Hold on, I could send you yours. Let's see.
Thank you.
Because you got it when I sent it to you, right? I could send it to the central bank where you want a KIDD.
You can send it to KIDD, please.
Okay. I'll send it.
You're gonna go out to Constructive Dismissal, yeah. Alright. So consequence of the big quick five feet, and I'm going to the subject.
Okay, just give me a minute and I can
That's
send
fine,
you
thank you.
yours.
Yeah.
Yes, Masha needs some muter thinger.
I even had, like now you told me.
Are we
I
supposed
don't
to have
think
a
you realize
separate
it's not on
copy?
mute.
Are we supposed to have a separate copy of the employment act? Or am I looking at the wrong book?
A separate copy of,
The employment act, the amendment.
yeah, the amendment is separate. Are you on Laws of the Bahamas?
Pardon?
Are you on Laws of the Bahamas? The website?
No, ma'am.
Because of the fact that
Okay. Hold on, Masha needs to mute so you can hear me.
like how he was treated by them. He said if he was to
I don't
fall
think
on
she could hear.
Wednesday tomorrow, he's not
Oh,
gonna
my
be able
goodness.
to.
I
Yeah.
just
You
messaged
don't
her,
want
ask her to
nothing to do
mute,
with-
but she's not looking at her screen, obviously.
Screen, exactly.
I messaged her as well.
It was weird for me too. I'm
Yeah,
like,
she don't realize it. She did it now. Yeah, okay. All right, just go in Google and type in Laws of the Bahamas. Let me know when you're there.
Okay,
Okay, click alphabetical.
I got it.
Leah,
Yeah. Employment is E. And you don't want, if you have the main act, fine, but we're going to focus on the amendment in 2017.
Okay, thank you.
Okay, all right, no problem. All right, I'm supposed to be giving somebody their grade. That's Kendria Martin, right?
Kendra, yes, thank you.
How you say Ken? Oh, they have it spelled Kendrea.
See, that's why I screwed up all around. Name spelled wrong, email address wrong.
So it's Kendra.
Yes, ma'am.
Okay, all right. I'll send it to
Thank
you, right?
you. Thanks.
Not a problem. Anybody else was missing their grade? No?
Got it. I
Okay.
got mine.
Okay, all right. Anyone was unhappy?
Yes.
Oh, I hear yes.
Yes.
So what do you,
Yeah.
so
Yes,
what,
a little.
so what are you going to
Yeah.
do?
Everything this time.
Every single thing.
Ms.
I
Archer,
think-
is it
Go ahead.
possible to get a copy of our result, not just the result, but where we went wrong, so we can see which areas we may be deficient in?
You could ask Miss Dean to scan it to you.
Okay.
I don't have it.
Okay, thank you.
Yeah, I don't have it. Now say, I remember I told you I don't do multiple choice, but I'm gonna have to give you all a supplement assignment if you want to be able to make the grade.
What is the passing grade overall?
70.
70? Okay.
Uh-huh. Hold on. And Ms. Dean would have sent you the breakdown.
Yes.
Okay.
You mean of the course in its entirety?
Yes.
Yeah,
Okay.
that's the final exam at 50, the case study is 20, the midterm is 20, and the class participation is 10?
Mm-hmm.
Yeah, Jesus.
Okay, say it again fast.
Jesus?
No. Capstone, 10%
Oh, yeah,
is
the-
participation.
Participation is 10, midterm is 20, capstone is 20, and final exam is 50.
Yes.
So you should know what your participation is so far. You know you have capstone in your hand to do. So that's 20% of the grades you got. Knowing that you have, so let's just say all you have to do is calculate this. You know how many classes you've attended so far. You should be able to estimate how much you think you'll get on the capstone. Because you haven't done it yet. So you know how hard you have to push.
Truly.
Okay, so based on your midterm, some people will have to
Do the class over like
the metal.
Oh, gosh.
So those who wish to do a supplemental can email me.
And that's gonna go against the midterm, or that's gonna go against the overall?
No, that goes against the midterm.
All right, okay, good, thank you.
Miss Archer, what
Mhm.
grade would you recommend that is necessary to do the supplemental, at least?
If you got below 70 and below, I'd say try. Because even with a 70, you still have 30 points.
Okay,
You try and get an extra set of points. Okay, so
Miss
everybody- go ahead.
Ms. Archer, you mentioned capstone. Is this the email you sent this week?
No, capstone, you would have gotten that earlier from Miss Dean.
Okay, which one would that have been? It's called capstone?
Yeah. Mhm.
Okay. I'll have to look for it.
Look for it and make sure you have it, because you should have started that by now.
Let me
A
see.
question, Ms.
Go ahead.
Archer, on the capstone, the survey that we're supposed to do, are we only surveying on the 4 questions they provided?
No, you could go beyond those. Those were just giving you a guideline.
Okay,
Yeah,
all right, thank you.
okay. Anybody else? Make sure we're on one page. Everybody is happy now. So you can see for the final exam, looking at the topics from last class, looking at the topics we're going to do today, you're going to have to study. You have to be able to differentiate when you read a scenario, what exactly is the issue that you're dealing with. So you have to focus now. I know for the beginning, you may have just read it, but you'll understand now that for this part, a lot of what you learned in the beginning is now built on top of that. So if you were kind of weak at the beginning, and you could tell that from your midterm results, or if you just crash study just for it, you really need to sit down and read it and understand it. And if you're having a difficulty with a particular topic, then you need to send me an email. Because when it comes to the final, then you're going to get confused, you're going to get frustrated. And it's not as if you don't know it. It's just that you can't articulate exactly what you're trying to say or what the issue is. Any comments? Because I need to find out what you found difficult in the midterm. Looking at the variation in the grades is whether or not you just didn't have the time to study, or you thought the questions were not clear, or you think you didn't have sufficient time. You need to tell me.
For me, I think part of it would have been the question and the wording for the questions.
Okay, I haven't seen it. So, okay, so I'll check that out.
Because I think for 2 questions, for me, they appeared to be similar when I realized they may have been separate, but they seem to have been similar in wording.
Okay, all right. Any other comments? Maybe you took it and you didn't study. I don't know. You need to tell me.
Well, that too, because I did a crash too, but even though I sat there and read through it, and despite having doing the crash, it was still a little off for me. Nonetheless, I'll carry on.
I think I could have taken my time and really go over it, because I think for me, well, one question I wasn't sure about at all. And then anything else just was a matter of, I probably just rushed through it.
Okay.
I'm like Kendra, I think the wording of the questions confused me on 2 of them, especially.
Okay.
So now that I see how it, because when I came out of the exam, I was like, oh my God. And then
Yes, me
think-
too. It was me too. It was me too, Lyndon. I was like, one was asking this, one was asking that, and I mixed them 2 up, but they seem to be the same.
No, but I and also for me, I after I finished the exam, I was excited. I was happy with them. And I mean, when I saw my score, I mean, my score wasn't bad, but I just felt that I would have done.
Could have done
You've
better.
done better. Okay.
Yeah.
Yeah, I feel the same way.
Because the questions were not hard at all. It's just like, I think I got confused a bit with how they were worded, because when I went back and I was sitting in the car and I went back and I looked over some stuff, I was like, wait, hold on now. But question says this, but
That's it
so
right
I
there.
think it was,
Yeah. And I was like, but I put this for that when this should have been for that.
right.
Based on what I read, I got them mixed up.
The exam was not hard at all. I think I just got
wasn't
a bit
hard, no.
confused. Yeah.
It wasn't hard. And one I just took a guess, and it happened to be, I explained it, but it wasn't the term of use. I think that's the one about the let the master decide. Yeah, I just
A
took a
higher up answer or somebody.
As a higher answer. And so I kind of broke it down. You could have figure it out, but they were looking for the actual term.
That,
Oh,
that was
child.
Oh, okay.
superior.
Hmm.
But at least it put us on guard because now we know we're not gonna have those type of questions. We have to
Oh,
really
no.
read. We have to really read
No.
and study because when you look at acts and trying to interpret cases and what have you, it's a total different ballgame.
Mm-hmm. Yeah. Hold on, I think same. Oh, no, that wasn't it. Okay, no. I sent an email and it said couldn't be delivered, but that wasn't you, Kendra. Okay, so, well, when you get the final exam, there's no coming back.
I know, right?
Oh, Lord.
So
You
we
have
have
to
to
write
study
a whole,
hard.
have to study hard, really study hard. Because the exam itself won't be hard. Because like I said on the last class, I will tell you what areas to study. So you
Right.
don't have to say, I have to sit down and study everything. But
Correct.
That'll be a help.
right, so the areas of study will also be built on what you did in the first part. And you'll see that too when we do one of the cases today, because
Okay.
they come together.
Okay.
Yeah. All right, so let's start. So this chapter's on employee termination, layoffs, suspension, garden leave, and dismissals. And we did some cases on dismissals last class. So I
Yes.
won't focus too much on dismissals because I think you got it. What's the section without looking up? What's the section for dismissal? Unfair dismissal.
Subsection 5.
You sure?
No.
Section 29?
You sure?
Not really.
It's part 4, it's part
33.
One part of it, yes.
Or 35.
35 to 40.
7.
Part what? What's the part?
Mr. Part 35.
Okay, you can get there. You'll get there.
1, 2, 3, 4, 5.
You have unfair dismissal, then you have summary dismissal.
Oh, 35 to 40, yes,
It's unfair. And what's summary dismissal?
31.
31.
Yeah, 31.
So the way to begin to study this is you get a little index card or if you have a notebook and you need to write down the relevant sections.
That's what I've been trying to do, yes.
Yeah, these are the key sections. And then you summarize it in your own words.
Okay.
And if every day you take 5 minutes or 10 minutes to say, okay, what are the acts? And you start to repeat them to yourself, read them. When you get in the exam, you'll be able to write them on a sheet of paper as soon as they say begin.
You have so much confidence in us.
Yes, that'll be your scrap paper and you'll be able to, when you write your exam, you'll be able to refer to the sections of the act.
Yes.
And once you put it in your own words, it makes it easy. All right, so let's go to layoffs. So, you know, in the Employment Act, in the main Employment Act, the main legislation, there was no section referring to layoffs.
I still don't know.
So the amendment in 2017 focused on layoffs, redundancy, and short time. So under common law, an employer is not obliged to provide work for an employee, provided he pays the employee his wages or salary. So that's common law, case law. However, there's no legal right for an employer to lay off an employee unless he is able to do so under the terms and condition of the contract of employment. So let me read something to you. The general rule at common law is that the employer must pay his employees who are available for work, even if no work can be provided for them. If there is an interruption in the provision of work, the employee is still entitled to be paid. However, if the failure to provide such work is totally outside the employer's control, it appears that the court will imply a term that employees are not entitled to be paid. That sounds clear?
Yes.
Okay, so now let's go to section 28 of our legislation. In the amendment, section 28. It says, except where there is an agreement to the contrary in a contract of employment, an employer shall not lay off an employee or place an employee on short term.
Wait, hold on, where's that? Ms.
We in
Arthur?
the amendment?
Amendments,
the
yes.
amendment.
Employment
Which-
amendment,
Oh, that's the-
2017, you want
Yes.
section 28.
Section,
28.
Okay,
I must be on the wrong thing. Because
I must be in the wrong thing too.
mine saying payment, this talking about redundancy.
Redundancy is the beginning, go down. Go to section 28.
That's my section 28.
No, 28 says layoffs and short time, short
Mhm.
time.
I look at it, so let me go, I have a copy I had printed, so let me go and look at the original thing.
Or go on Laws of the Bahamas.
Yeah, I probably gonna have to do that, because it's something I printed as I was reading. Let me go pull that up right quick. Okay, and we doing,
Section 28, layoffs and short time.
okay.
You found it?
No, but we can go on, I'm looking, but we can go on while I find it. Once I get it,
Okay.
I'll advise.
Okay.
Thank you.
So except where there is an agreement to the contrary in a contract of employment, an employer shall not lay off an employee or place an employee on short time, except for one or other of the reasons specified in subsection 3. And unless the requirements of section 28A are complied with in relation to the laying off or the placement of the employee on short time, as the case be. So let's go to subsection 3. Subsection 3 says the reasons for laying off are that the employer has temporarily ceased or intends temporarily to cease to carry on the business for the purposes of which the employee was employed by him, or has temporarily ceased or intends temporarily to cease to carry on that business in the place where the employee was so employed. The requirements of business for employees to carry out work of a particular kind, or for employees to carry out work of a particular kind in the place where
Ms.
the
Archer.
employee, go ahead.
Sorry, I'm totally lost. Are we in the act or we in the amendment 2017?
Amendment.
Okay, I'm in the amendment, so I must have the wrong one then.
There's
I
only
put it-
one.
I put the link in the chat as well. So if you click on the link, you'll be able to find it.
Let me see, because I ain't finding it.
Yeah, because I have
Oh.
it up and it says that it starts with Constitution Amendment Bill 2017.
No, that's wrong. It's not a constitution. It says
Okay, I'm-
Employment Amendment Act 2017.
Oh, I'm sorry, I'm the wrong one then.
Yeah,
Oh. I
let me
see.
wait for everybody to get it.
If you click on the link in the chat, it'll take you directly to it.
Okay.
Yeah, I see that. Thank you.
Everybody's there now, right? Just about.
Yes, I got it from the
Okay.
link. Thank you.
Okay, all right. So to lay off, the act actually tells you when a company can lay off its employees. Under section 28, subsection 3. Because B says requirements of the business for employees to carry out work of a particular kind, or for employees to carry out work of a particular kind in the place where the employee was so employed have temporarily ceased or diminished, or are unexpected temporarily to cease or diminish. Then it says an employee shall be presumed to have been laid off for a week where he is employed under contract on terms and conditions such that his remuneration under the contract depends on his being provided by the employer with work of the kind which he is employed to do, and he is not entitled to any remuneration under the contract in respect of the week because the employer does not provide the work of that kind for him. So let me read you a case. It's an English case. In the case of Browning versus Crumbling Valley Collieries, that involved a serious land fault in a colliery. The owners closed the pit until repairs had been carried out. The miners sued for loss of pay during the closure. It was held that the failure to provide work was totally outside the employer's control, and as such, the implied term that the employees were entitled to payment would not apply. That sounds clear to you?
Read it one more time, Ms. Archer.
Okay, let me read it one more time. In the case of Browning versus Crumbling, it involved a serious land fault in a colliery. That's like a mining. The owners closed the pit down until repairs had been carried out. The miners sued for loss of pay during the closure. It was held that the repairs to provide work was totally outside the employer's control, and as such, the implied term that the employees were entitled to payment would not apply.
Okay, I agree.
Okay, all right. It should be noted that if the employer finds it merely difficult, but not impossible to provide work, the general principle will apply. So what's the general principle for laying off or short time working? The employer must pay his employees who are available for work, even if no work can be provided for them. That's the general rule.
That wouldn't apply because the mine was closed. They wouldn't have been able to pay them in any, give them any work anyway.
Exactly, exactly. So remember that when you write your exam.
Yes, ma'am.
So you know what the general principle is, and you know when the employer is not entitled to pay.
Right.
And under Bahamian law, if you're going to lay off, it tells you exactly when you can, the reasons that you have to give the court as to why you are laying off your staff.
Right.
You have temporarily ceased, or you intend and temporarily cease business to carry on your business for which the employee was employed by the company, or you have temporarily ceased, or you intend temporarily to cease to carry on that business in the place where the employee was so employed. So it's two things. One is you temporarily cease to carry on the business, and the second one is you're not doing that business anymore in the place in which that person was employed to work at. It says then that the minister may, after consultation with representative of employees and employers, make regulation with respect to the layoff or placement on short time for certain sectors of industry and for specific categories of workers. Now, I haven't seen those regulations as yet. And remember, this is a new piece of legislation. 2017 is very, very new in law. So it should be noted that even if an employee has agreed with his employer to be laid off previously, that does not allow an employer to lay the employee again at a later date. in the absence of an express term in the contract. So an implied term cannot be imputed into a contract of employment due to past agreement or past conduct of the employee. It is a good practice to ensure that written terms regarding layoff and pay are included in the contract of employment for avoidance of doubt or dispute regarding the conditions of layoff and employee wage or salary entitlement. So I can ask you now, does your employment contract include provision for layoff, or is it in an industrial agreement?
Ms. Archer, can you use force majeure as to cover that?
Yeah, but see now, then you leaving that open even for more argument rather than putting in a specific clause just for layoff, especially how we have the legislation.
Okay, so the preference would be to put the specific clause as opposed to
Yes.
something as ambiguous as force majeure.
Yes.
Okay.
Now, before you would have gotten away with that if you were not in an industrial agreement, because we
Okay.
didn't have the law, but now you actually have the law and it tells you what's required.
Okay, so if you don't have an industrial agreement, then you could get away with that?
I mean, use the force majeure.
Yeah.
Yeah, but I'm saying now, because we have the amendment 2017, I would actually state what it is that you require for a layoff or time or short time. Because I remember now, these legislation for the amendment of 2017 hasn't been challenged as yet.
Okay.
So even though that's a customary practice in the Bahamas, whenever there's an economic turn down, the common law provides that an employee is still considered an employee of the employer during a layoff period and is entitled to receive and continue to receive his wages and salaries during such period. So the pandemic again brought this feature out.
Mhm.
When people were doing layoff, short time, a lot of people were let go. And it's a time now to look at these contracts of employment.
Which are being broken all the time in this country.
Yes. That's why you're in the class now on both sides, employer and employee, to make sure that your contract includes everything that it should include
Well, we've been paid straight through, so
with all benefits.
with all benefits, yes, ma'am.
Okay, all right. So you see, they followed the law.
Yes, ma'am.
Okay. In some instances that did not happen.
I know, right?
Okay.
The
All right.
hotels especially.
But they're on an industrial agreement. So that's when those who are part of a union have to make sure that the contract covers what it should cover. Because that's the source that you're going to turn to. What does the industrial agreement say?
Well, we are also under an industrial agreement, so.
But that's why you have to keep checking it and making sure that it's correct.
Yes.
And as you can see, this area of law is not like criminal law. It's constantly changing.
Yes.
So you have the act itself, but you also have to look at common law, case law, and how things are moving in the UK and in other Commonwealth jurisdictions. All right, suspension. The common law does not give an employer any power to suspend an employee for misconduct, as defined by the law. The employer only has the power to dismiss an employee for breach of the contract of employment or for gross misconduct. The power of suspension of an employee. Go ahead.
Ms. Archer, you say, I'm hearing you correctly, you're saying the employer doesn't have the power to
Under
suspend
common law.
Oh, okay.
Under common law. Under common law.
Okay.
Okay, all right, so
Where are you
remember
reading from,
now,
Ms. Archer?
this is
101.
page 101 at the top,
Okay.
suspension now. We just did
Okay.
layoffs, now we're doing suspension. Remember in law, as a Commonwealth jurisdiction, you'd have done this in the first part. You have to remember there is common law on your left hand, and on your right hand is the Bahamas legislation. So
Okay.
as a Commonwealth jurisdiction,
Yes.
our structure goes magistrate, supreme, civil, privy council. That's how our courts operate. Now, because we are a member of the Commonwealth of countries, we follow precedents, common law precedents. So yes, we have our law on our side. Yes, we have our case law that we've developed in the Bahamas. But when we are arguing a matter or an issue, you rely on common law, case law from England. You can look at case law from any other Commonwealth jurisdiction, Canada, Jamaica, all of those. So it's a combination of two. And you'll see when we're about to look at this case and see how the courts pull on different cases. Now, the only way the cases from common law would not relate if is our law itself is written differently. But in most instances, in common law jurisdictions, the wording are very similar. So there's always common law in your left hand, and on your right hand, you have the Bahamian law and the Bahamian cases. So the power of suspension of an employee for misconduct, an employer must ensure that there is a term in the contract of employment which allows him to do so, or that there is an implied term that is imputed into the contract due to customary employment practice. And that was brought out in the case of Heenley versus Pease. So let's go to the case I sent you called Brandley Roberts, and Perfect Luck. You have that one?
Yes.
Okay, so it says here that Roberts was terminated from her employment with Perfect Luck in January 2017. Following her termination, she brought an action against Perfect Luck on the basis of unfair dismissal and breach of contract. She was suspended without pay, constituting a breach of her contract of employment, and that she was unfairly dismissed because she was not given the right of a fair hearing. And the judge in the Supreme Court dismissed her claim. And so now she's at the Court of Appeal. So at the Court of Appeal, they said that suspension without pay in the absence of an express agreement is a breach of contract, entitling the employee to sue for damages as a result of lost wages. It does not, however, bring the contract of employment to an end. There is nothing in Roberts' pleading which asserts that such a breach was fundamental. And when contract. So notwithstanding submissions being made on unfair dismissal, particulars of the alleged unfair dismissal were not pleaded. So what they were saying was that her attorney did not plead on the matter of suspension without pay. So let me send you to the section when he speaks about Heenley and Pease. Go to paragraph 10, page 9. So he's saying, the judge is saying in the statement of claim, paragraph 7, it says the defendant suspended the plaintiff without pay for 5 days, contrary to the plaintiff's contract of employment. It is to be further noted that there is nothing in the pleadings which asserts that the alleged breach was a fundamental breach, which went to the root of the contract of employment. Remember from the first half of the class, you would have learned that the employment contract is an actual contract between employer and employee. And there are express terms and there are implied terms. And the employee has a duty and the employer has duties. And all those fundamental things are always what you consider when you look at when there is a breach, whether there is a fundamental breach that goes to the root of that contract of employment. So always remember that once someone is in your employ, it's the four corners of that contract, along with any other supplemental documents that are referred to in that contract. That is the actual contract. You don't go outside of that. So he says that her counsel relied on the decision in Carlton Butler versus Paradise Island, where the judge in that ruling of Henley and Pease and partners, and Henley and Pease is the leading case for suspension. And Henley and Pease, go to paragraph 11. This case established that in the absence of an express power giving entitlement to do so, the employer acts in breach of contract by suspending the employee from work without pay. So whilst the contract continues, the employee can sue for damages representing lost wages during the period of unpaid suspension. And then he said why the case that was presented by her attorney was wrong. He said,
Attorney mess up.
Yes. So Mr. Ferguson, her attorney, was able to provide us with no authority, which supported his submission that suspension without pay, in the absence of express power to do so, constituted a fundamental breach which brought the contract to an end. Mrs. Major submits, that would be the attorney now for Perfect Luck, that there is no such evidence that the appellant's suspension without pay amounted to a repudiation of the contract of employment. She noted that at the end of the appellant's period of suspension, she returned to the workplace for the return from suspension meeting and continued to participate in the disciplinary proceedings. In addition, the attorney submits that the employee, the appellant, is bound by her pleadings, and she further submits that the appellant did not plead that her suspension without pay amounted to a repudiation of the contract of employment. And counsel concluded that in any event, it is not for the court to speculate regarding the details of the alleged breach, and that in the absence of any particulars, the appellant's claim for breach of contract was bound to fail, and it failed because her attorney did not plead on her behalf. So that was that case which you could read. Garden leave. So garden leave is a situation where an employer gives a senior or executive employee a long period of notice of dismissal in order to prevent him from working for the competition. In essence, the employer gives the employee a very long notice of termination in terms of the length of notice of length of time of the notice. So whilst garden leave may be an express term of contract of employment, the efficacy of such terms is dependent upon the facts of every case and the nature of the employment. So you notice some people will have notice of 1 month, some 2 weeks, some 3 months, some people 6 months, some 8 months. In some cases, it may even be 1 year. Resignation. It's important that an employee communicate to his employer his resignation in clear and unambiguous terms. An employer is empowered to accept his resignation and terminate the contract of employment immediately. However, there are instances where the conduct of the employee and the facts of the circumstances surrounding his resignation may diminish the efficacy of his resignation. notwithstanding his clarity in enunciating his intention to resign. So in the case of Sovereign House Security Services Limited versus Savage, and in that case, Savage was employed as a security officer. After discovering a cash shortage, his superior rang him and suspended him without pending police investigations. Savage responded by saying, quote, "I am not having any of that. You can stuff it. I'm taking the rap for that. I'm not taking the rap for that," end quote. He then rang his immediate supervisor, Mr. Scrooge, and told him that he would not be in to relieve him the following morning as arranged. Savage subsequently complained to the Industrial Tribunal of unfair dismissal. The tribunal found for him the employer's appeal was dismissed, and they appealed again, and it was held that the employer's appeal was dismissed. The judge said, "In my opinion, generally speaking, where unambiguous words of resignations are used by an employee to the employer, direct or by an intermediary, and are so understood by the employer, the proper conclusion of fact is that the employee has in truth resigned. In my view, tribunals should not be astute to find otherwise." But he then continues, "However, in some cases, there may be something in the context of the exchange between the employer and the employee, or in the circumstances of the employee, him or herself, to entitle the tribunal of fact to conclude that notwithstanding the appearances, there was no real resignation, despite what it might appear to be at first sight. And there was that evidence from those two witnesses on which, in my judgment, it was possible for the Industrial Tribunal, were they so minded, having seen and assessed the witnesses giving evidence in the witness box, to conclude that the words actually used by the employee to Scrooge were used in the heat of the moment and should not have been accepted at full face value by the employers. There was, in my opinion, evidence entitling the Industrial Tribunal to make the findings which they did in paragraph 7 of their decision, which was, as I think, just as much one of fact as their findings of fact set out in paragraph 4 of the decision, that the applicant was not tendering his resignation to Mr. Scrooge. Because you see what he said? "I'm not having any more of that. You can stuff it. I'm not taking the rap for that." And that's what he said. Additionally, it must be noted that in instances where an employee is induced or coerced into resigning from his job, it is the employer and not the employee who terminates the contract of employment and must compensate the employee accordingly. And I sent you a case on that, where the guy said that he was induced.
Ms. Archer,
Yes.
by you bring that up, I remember my nephew I was telling you about, right?
Yes.
Okay. I got a copy of his job description, right?
Mm-hmm.
And the job description does not mention cleaning any windows.
Does anybody else clean windows? Who
Yes,
does
they
the same
do.
function?
Yes, there's somebody who does that.
But the other people who has the same job description as he does, do they do that?
Clean the no, I don't know what theirs is, but his job description does not refer to it. Says he's to clean out the plane and empty the trash. And it doesn't have any other duties as assigned.
Oh,
I was just gonna ask that too, if it had any other duties.
It
Let's
doesn't
put
have
everything
that.
into
No, it doesn't have that. And then when they wrote, when he wrote him the termination letter, he said in the termination letter that my nephew said, I'm not cleaning those windows and you could fire me. But my nephew said he never said that. And he refused to sign the letter as well.
oh, okay.
He said he never said that. He said the gentleman said, when he told the gentleman, they said, you have somebody to clean the windows, you know, why are you asking me to clean the windows? You have somebody employed to do that. Say the gentleman just told him, you fired.
Hmm.
So he said he never told that gentleman that he could fire him. He never did that. And they're
Was
running him down and emailing him this letter for him to sign. I told him, no, sign anything.
No. Don't sign it. Okay, so
No.
you're gonna hear now about an employee who signed a letter. Let me see which one
Ah.
of these two it is. Yes.
Okay.
Is it this one or is it this one? I think it's this one here. Okay, so I'm not sure if it's this one. I read so many of these now. Okay, hold on. Don Smith was employed as an assistant plant operator with BPL, Bahamas Power and Light,
Okay, I see
from
that.
January. Yeah, Bahamas Power and Light and Don Smith. So he was employed as an assistant. Yeah, this is the one. He was employed as an assistant plant operator with BPL from January 2004 to 2010. And he suffered a seizure, which severely affected his performance on the job. So in 2017, he was given a disability retirement package letter by the appellant. And he signed a deed of release and accepted the package offered.
Wow.
And in April 2018, he went to the industrial tribunal alleging that he had been unfairly dismissed.
He signed the letter.
What? After
Yeah,
you
he
take
signed
this
it.
off?
Yes. The vice president of the tribunal held that the respondent was under duress when he accepted the disability package, and that the appellant had unfairly dismissed the respondent. So now BPL is appealing that decision. So at this level now in the Court of Appeal, the appeal was allowed. They said the judgment of the vice president is set aside and any funds ordered to be paid by that judgment, which exceeded the settlement agreement between the parties, fall away. So they said that the vice president's finding of unfair dismissal was based on her view that the appellant did not do enough to accommodate the respondent in remaining employed. But unfortunately, in her finding, the vice president does not say why what was done was inadequate, nor did she identify additional steps which they could have taken to accommodate the respondent in the circumstances of this case. And in the circumstances, they found that the settlement arrived at between the appellant and the respondent was effective, and therefore it was binding on both parties. And by virtue of the compromise, they had agreed to forego any further claims. So if I go now, and let me tell you a little bit about what he did. So he was a part of a union. Is your nephew part of a union?
They don't have one. At the airport, there isn't any.
Oh, okay. So this guy was a part of a union, and his duties was not limited to the following. Guided by a qualified operator or shift foreman, operate all boilers, gas turbines, reciprocating engines, and diesel generators. Maximize continuous, safe, and efficient operation of generation sites through proper air, fuel injection, water, cooling water, lubrication, and emission reduction. And then dip boiler to ensure maximum pressure levels. So after about 5 years on the job, he began developing migraine headaches and nosebleeds. After
Probably from
6
that.
months, I'm about to say, I didn't want to stop in the middle of the paragraph. He should have taken that angle.
Right.
After 6 months later, in April 2010, he suffered a grand mal nocturnal seizure to which he was hospitalized and treated in the emergency room. Because you see what he's dealing with?
Yes.
Engine and oil and yeah,
Yes.
he should have.
And
So that's hazardous stuff he's working with, and it affected him. So
Yeah, he should have. So when the respondent returned to work, he was still not fully recovered from his ordeal, and he began to suffer some adverse effects. The prescription which he had been given interfered greatly with his ability to function normally. Some of his effects that he experienced were dizziness, blurred vision, and he had a very hard time concentrating. His condition did not improve, notwithstanding further treatment. It appears that he was relocated to a desk job, which did not work out. The parties' evidence conflicted on why this was not successful. However, on the 30th of June, 2017, he received a disability retirement package from Marissa Mason Smith, AGM, HR, and training at BPL. And on the same date, he received a disability retirement letter from Chiquita Johnson, manager of compensation and benefits. After meetings with the parties, the respondent signed a deed of release and accepted the funds offered pursuant to the agreement between the parties. However, on the 26th of April, 2018, the respondent caused an originating application to be filed on his behalf, alleging that he had been unfairly dismissed. In this evidence before the tribunal, the respondent acknowledged that he signed the deed of release and accepted the money, some of which he had already spent. However, he stated that he felt that he had no other choice but to sign the letter. He claimed that he got no advice from the union and that although he received advice from his attorney, he did not feel that not accepting the settlement was an option, as the appellant had indicated that it represented their final offer.
They bully him, they strong arm him into that.
Well, that's why he came on the case of duress.
And he said, but did he go to his union for them to say they didn't represent him?
Yeah, he said they didn't give him no advice.
Oh, wow, I can't believe that.
I used to say that's strange, because even if they tell you, even if it's just a yes or a no, they could tell you something, they ain't just dismiss you.
But
I
that's what
believe he
said.
signed it because, like you said, a lot of times people sign these dismissal letters
Desperation.
because they are broke
And desperation, yeah.
and they
Yeah,
don't know
because
how
there are a lot
long
of
they're gonna
medical
be out of a
expenses.
job. Yeah.
Mhm.
But when he started having those issues, that was the time for him to act, because it's quite obvious that the condition he developed was as a result of the actual job he was doing.
On the job,
Ah,
that's on the job. Could that be considered then on the job injuries?
yes.
Industrial?
He should have gone to
Yes.
the root of the. He should have gone to the root of the problem.
That's where it
Right.
started.
That's where it started.
And I am sure if he had, the union, if he said he got no help from the union, if all of that was explained, and I can't see him not getting any help, because that would have been their angle, or should have been.
Exactly. Exactly.
Mm-hmm.
And so now, once you sign a letter, that means that you accept all the terms, all the conditions, and that it is the end of the story. There's no other recourse. You've got your money, you go your way and I go mine.
You lock yourself
Right.
in.
Because he signed a deed of release. So he released
Yes.
them from all liability.
That's right.
You lock in now.
So after
Yeah,
he signed that, he
locked in.
couldn't go and now make a claim,
Mhm.
because you already released them from any other future or whatever.
Yep. And that's why we agreeing with you that he shouldn't sign any letter.
No,
when
I
you
told him not
sign
sign
these-
anything.
Yes. Don't sign. Because if you sign,
Get over.
So
yeah.
that goes back, Ms. Archer, that almost goes back to Chili Willie and the guy what is his name? Who didn't sign his termination letter that
Yes,
came back in a
and then
different format,
went,
right?
right, he went straight.
And that came back in a different format because he didn't sign the first one. So yeah, that's true, Lyndon. He shouldn't sign anything.
Yeah, but like I just said, he put things in there. So my nephew tell him fire him, and that's not. Why would you tell somebody to fire you? You were only trying to explain that, hey, that's not for me to do. Why you were asking me? He's just trying to find out why you were asking me to do this.
But then
Right.
back to Chili Willie and the guy said he had put additional information in that too
Yeah.
Yeah.
about the cooler number and all that.
Mhm.
But Mr. Cartwright didn't like him. Mr. Cartwright trying to get rid of him long time.
Long time.
Ms.
Long
Archer,
time.
the fact that in this case, the gentleman was represented by counsel, in fact, he indicates that he was given advice by the counsel. Doesn't that factor in? Because if his counsel had told him don't sign and he signed, he's gone contrary to his counsel.
Yes, yes.
That's another thing.
Mhm.
He might have gotten counsel after he signed it.
The devil, that would be foolish.
Yeah.
And then, and a lot of times when you're being fired, you're not thinking straight. So you're just supposed to just stop and don't do anything.
I was gonna say, when you're getting fired, you don't do nothing right there, and then you make
Yeah,
everybody wait.
you take a
You go
take a
straight-
break.
Yeah, you go straight for legal counsel.
You take a break and try to assess the situation, don't sign nothing because you are not thinking straight. So you could be signing anything.
Exactly.
Yeah, I get the impression that he got counsel prior to signing because it says he claimed that he got advice from the, he got no advice from the union. And although he
Union,
received
right.
advice from his attorney, he did not feel that, so he hadn't signed yet at the time he got advice from his
Mhm.
attorney.
Yeah, he worked on, he acted on his feelings.
Obviously.
He let emotions.
Yeah, but
get
his
the better
feelings
of
should
him.
have kicked in when he got sick.
His emotions got the better of him.
Yeah. His sickness was due to his job.
That's right.
But that would still have to be proven, even though it sounds on the face of it that it could have
Yeah,
been.
he had to
Yeah,
prove it, but
he
most
could've.
likely that's, yeah, he could have.
Because
He could have
based
had
on
a
the
pre-
medication and the doctor, I'm sure when they gave him the medication, they had to know what they were giving it to him for. So what his symptoms were and the type of work that he did, I'm sure all those questions were asked when he went for his medical treatment.
Mhm.
Okay,
What do you what do you do? What do you work with?
right?
Mhm.
Because that sounds
And-
like a chemical issue to me.
About the saying, are you dealing with oil and stuff and you're getting headaches?
Mhm.
Yeah.
And
But
he's
you know what,
admitting that.
it almost feels like since he wasn't guided that his injury or the symptoms he was experiencing were a direct result of the work he was doing, it may indicate that he had a pre-existing condition or was already prone to having seizures that may have had nothing to do with his job. So I think we can't jump to conclusions that it was
Yeah.
definitely his work that caused the injury.
Yeah, but he could have ruled it out though.
Yes, exactly.
Yeah.
But you
And if
know,
it
when you go
found
to
to be
the
so.
when you go
Go
to the
ahead.
service station and you smell that gas when they're pumping it into your car, you smell you smell that. So you can imagine if that is the crude that you're actually working with at BPL or BEC or whatever. You can imagine there's a whole bigger difference.
Mhm.
Yeah.
And so over a period of time, it may not have affected him in the beginning, but over a period of time working with that daily, that could creep up on you.
Yeah, but then too, you have to remember that with the health and safety, the company is going to take whatever steps it can to protect the employees. I worked in a pharmaceutical industry and extreme measures were taken to protect breathing of employees who were working with hazardous materials. So
We're talking
again,
about BPL here. Come on, they had the crude oil all about on the floor. People talked about it being in places where it shouldn't have been. So come on now.
Yes, I would say too, Catherine, because if he disclosed previously that he would have had a pre-existing illness, then wasn't it their place to then post him or place him somewhere then that
Somewhere
would
else,
accommodate
yeah.
Right.
accommodate
Correct,
his
yes.
pre-existing?
yeah,
So then they
Not
probably
again,
didn't do their due diligence, or he probably didn't pre-disclose or something. I made a reference to what you mentioned.
something is missing. But anyhow, that was it for him.
Finished deal. Because he signed.
Yeah. So I don't want y'all in HR now to force these people to sign because they go in the tribunal and say they did it under duress.
And that could stand up in court.
Yes.
Sounds like we need to look at formulating some releases. Along with that final settlement, I mean to put some verbiage in there so we could stay out of the courts.
Of course.
Sound like
And
I
then-
just
and-
give me
and
an
you-
idea.
Right. And then you ask them to let their lawyers look it over before they sign, and then you're good to go.
That'll never
That's
happen. But that's what you should do. The
That's what
employer
you should do.
Even
employer
instead of
should-
like read, you just put that to the bottom of it, very, very fine print.
Not too
Keep
fine.
waving the
Not
check.
too
You
fine.
just
Oh
keep
my
waving.
God.
No, you just keep
Very,
waving the
very
big check and say, well, you just show them that check, and that's all they thinking about.
Oh my goodness. But you shouldn't sign anything without reading it. And if you don't understand something as important as that, you should.
But
That's what
say
you
very,
should
very
do.
fine
You
print.
should go to an attorney.
Yeah.
You should.
They want that check. That's all
I
they.
know.
Yeah, but that check will cost you in the long run.
Mm-hmm.
But that I think is a lot of times the situation because people are desperate. They don't know when they're going to get another job. And so that money's going to come in handy.
And you find too, they may not sign right then and there, but you let a week or two go by and the tribunal process is so long. They just say,
Hello.
just sign this so I can move on with my life. Okay.
Wow.
Yeah, but then they still go to the tribunal
They
because they
still
have the
go.
money. Like the
Yeah.
guy said, already spent some of the money. But
Mhm.
anyhow, he said he's there.
But
See if
my
he can get
nephew
anything else.
My nephew can wait on this long process because he lives at home and
He never have nothing but time.
he can wait.
Miss Archer, I have a quick question, just going back
Go
to
ahead.
garden leave. Do you find it a common practice that when taking on a new offer that the employee can negotiate garden leave into their contract? Like, I know the employer may do it to protect themselves against competition, but do you find that employees are doing it, like to write a long period?
No. If anything, what the employee would be trying to do is to reduce it.
Yeah, but I mean, I'm thinking of like if you're taking a risk and going to work for a new startup company and you may be leaving a long-term job, that's something that's more stable, but you're taking a risk. You may want to say, okay, if this thing falls south, at least I have a little breathing room with this a longer notice period rather than the month. I could write in maybe 6 months. I mean, it's a risk if I want to leave, if I get another offer. But
I haven't seen it. No heard of it. I don't know if anyone else in the class has. Not from the employee side.
From the employer. Okay. Yeah, I've seen it on the employer side, but I mean,
Yeah,
it
I've
works.
never seen it on the
It
opposite
worked
way.
out to the benefit of that employee when it was time for us to let her go, that we had to pay her all of this and we wanted her to go on right away. We had to pay all of this notice period.
Mm-hmm.
So I was
So
just
garden
thinking,
leave.
Yeah, but
Ms.
think
Archer.
about it. But think about it from the way that you're proposing. That means that you're opposing to an employer when he's already budgeted that this is the package I'm giving. And now they wanted to have garden leave included in it for more months. That's more expense. No, they're not gonna do that.
So Ms. Archer, so garden leave is with pay.
it's a longer notice
Yes.
period. Mhm.
Okay,
Mm-hmm.
okay. So the employee isn't gonna lose anything.
No,
Employee's
but the
gonna,
employer will.
the employer will. But I
I
mean,
said, like, no, I'm saying the employee doesn't lose anything in this agreement.
No.
They
It's
consider that
just
as
that
long
if
as.
it's
Go ahead.
whether or not the competitor is willing to wait that long for you.
Correct.
yeah.
So look at
Okay.
this, look at the cryptocurrency business now, which is fast moving, active
Mm-hmm.
business. If you're moving from one to the next one, they're gonna put garden leave in those contracts
Yep,
because the competition is stiff
yeah.
and they pay very well.
Mm.
So you moving from one where you can be paid 200,000 to one that's gonna be paying you 350.
Mhm.
Trust me, you're gonna have a long 6 to 8 months to wait.
Yeah, but you may have your new employer, they may ask you, okay, what's your garden leave? We'll just pay the notice because if we really want to bring you on board. I mean, some of these big time.
So that's when you have the sign-on bonus.
Mhm. Yeah.
This is to
The employer-
compensate for that loss.
The employer doesn't have any recourse in a case like that where they've implemented garden leave and the employee still vacates his position at the enticement of the second or his new potential employer. The employer doesn't have any recourse on that.
No, not really. You could take them to
Wow.
court.
Hoping to get what back?
Because don't forget now, it's just the same as the other way around. Yeah, you can just say, all right, the contract says I have to give you 6 months notice. I don't have time for 6 months notice. How much money do I owe you? Because who you're going to, the competitor may then decide that they're going to pay it.
Yep.
Now comes the questions is when they're going to a competitor, what exactly are they going to do? If you think that they're taking with them trade secrets, then of course you're going to go to court.
Mm-hmm.
So it depends on the position and what you actually do.
I've never heard of garden leave locally, so I found that interesting.
I've
Oh,
never,
no,
Never heard of it either.
I've
Yeah,
never heard
that's
of that. I never knew that was the term used for it, but I
But
have
they have it.
the
They have it.
contracts longer notice periods.
Yeah.
Mhm.
Probably in these offshore or foreign companies maybe.
Yes, they do. In the offshore, even in
Okay.
some of
Even
the
some-
private schools, they have 6 months, 8 months, a
Right.
year.
Right, I have that in my contract, but it wasn't given that name. It just said that I had a longer notice period in the event that I wish to
Yeah.
resign.
Mhm. And that really makes you think if you get an offer, because you have to
Mhm.
think about whether the person who wants you now is willing to wait that time or willing to give you a sign-on bonus to compensate for that.
Yep.
Interesting.
They have to really, really want you to give you
Yeah.
that amount of money. Now, let's just say it's a business that's just starting up. Someone you know who's just in the idea of it. And they say, well, we have to put the company together. We have to get our approval. So we're looking at maybe another 6 to 8 months. We'll be ready for you.
Mm-hmm.
But you gotta have that
Then-
in writing, because that means you giving in your notice for this
But
company.
that's a risk you're going to take.
Yeah, that's a real risk.
That's
You
a
gotta
real
have-
risk.
Yeah. You put in your notice,
Right.
and the company,
Or you would have one that just got a license, just starting up, and they say, yes, they want you in your knowledge, but are they willing to pay that amount of money to bring you on board? You got to be something that they actually want and be bringing a lot to the table.
And that's what they consider the sign-on bonus?
Sign-on bonus.
Huh?
Yes, ma'am.
Yeah. So,
Wow. Okay.
yeah.
It's the sign-on bonus is any enticement they could use to get you on their ship faster.
Yes.
But I noticed Ms. Archie said it because it's most times if it's a tough position to fill or a tough job to get someone to fill,
Mhm.
they would offer
They
that.
will pay you. Yeah, they'll offer to you.
But when you have little simple jobs that certain departmental managers and you given a sign on, boy, anyway.
No,
Lyndon, what you say? Only in the Bahamas, eh?
I am telling you.
the sign-on bonus. Yeah, the sign-on bonus will come in, let's say you have a lot of regulatory issues to deal with, and you have a window, and you see that your time is coming, you need someone to come in there and deal with it rather quickly. So that person has to leave their job and come. That's the expert knowledge or expert experience that you need at this point in time in order to save your business. You will pay a sign-on bonus.
Actually, sometimes that'll be BS too.
Yes,
Especially for the people who, especially for the signee.
But hold on, that comes back down to human resources and the interviewing technique and the person who's head of the department.
Or
the person who's doing
I plead the fifth. I know we don't exercise that here, but I can plead that.
Really know what they're looking for, because you have to be able to tell between someone who actually and someone who's BSing. A lot of HR personnel. I mean, no offense to nobody, but you must learn the art of BSing.
In the Bahamas.
People talk very well. Put a pen in their hand, a piece of paper, they lost. They can sit in any meeting and riddle off anything, but put them to a pen and paper and put them in an office and say produce. They cannot do it.
Wow.
Anyway, yeah.
We have a lot of that.
Yeah, truly.
So they can talk the talk, but they can't walk the walk. All right, job abandonment. You have a lot of that, people abandoning their job?
Hell no.
You sure?
What, in this day and time?
People doing it in this day and time.
Really?
Yes.
Yes.
Others can't find a job?
I think more the younger people in the society, like them 18, 19, 20-year-olds.
All right.
Who happy-go-lucky? They just bouncing.
No, they're not happy-go-lucky. They're from a different generation.
They
Remember,
don't have no responsibilities.
Nothing to do with that either.
So what it is? They just want
law too.
They just want to be slack?
No, they're different.
Oh, okay.
And I think I agree with that part too, Ms.
They're very different. They're very different. Their goals are different. Everything about them is different. They do not think the way we think.
Exactly.
And they're not taking on any stress. They're not doing it.
And it's also
Yeah,
careless.
I think it was
because-
actually, they still ain't, a lot of them still ain't learn the value of actually having a job. Like,
That's
but
not
then it leads
important.
back to no responsibility because it's
No, but you come in with these words from the 60s and the 50s and the 40s. That's not in the, no, I
That
work.
ain't their vocabulary.
No, I work, I do a job. Don't pressure me.
Because I mean, some of them, you know, the job abandonment is, you know, you don't
Say,
report to work for
you
3
hired me, you
days.
say, I'm
That's
supposed
job
to do 1, 2,
abandonment.
3, 4.
Right. And some are just careless, you know, it's a long weekend, friends are on the ground. They don't see
And some of them, as far as they're concerned, they could just find something else.
Right.
Yeah. Ironically, I had a case like this last week, and I had an employee who was out on sick leave from August of last year. And from August to December, they had provided medical certificates to cover their time. And I guess the Christmas season got the better of them, and they forgot to submit their sick slip. So
having a ball.
They was having a ball. And so the last week in December, they decided to say, okay, well, I have my sick slip to cover that period, but so much time had already passed. It was at least almost 3 weeks. And they just wanted to submit another sick slip, not return to work. Just to, and so it was like, you know, that's it.
Ain't no way.
Man. They having a good time.
And so we would have paid them their accrued vacation for the time, but they were seeking severance.
So let me ask you something. When they started to send in the sick slip, did you send them to your doctor?
Yeah, I would have.
We didn't send them. We didn't send them to the doctor. We took their word at face value because
no, never do that. Never do that. Never do that.
But
there's no connection with these doctors.
This is an employee. This is one of those employees that you were happy that they were off because they were a problem. You were just like you weren't paying much attention to it, so you were just, and we weren't paying them. They weren't receiving any pay from us. They were just claiming from national insurance after they had exhausted all of the paid sick leave.
Yeah, but that's a reputation risk, and especially if one interested in seeing them, it's better just to terminate.
Yeah. Well, I guess from the point of view that maybe, I mean, I know I had spoken to them and I was like, I hope I ain't getting played, because I started to feel sorry for them the couple times I called the check.
No, it's no emotions in this.
I know. I said, well, I don't think that they out there partying or having a good time.
Right. Yeah.
I say, I really said it sounds sincere. You know,
that's the plan.
You know, these young people, they crafty. They know how to tug on your emotions and that.
Go and get swing.
She gets swing big.
Yeah, but they didn't have a record. They've been there for quite some time. They didn't have a record of abusing the sick leave. They never were out because they never were out sick. So that's why I took it to mean, you know, this.
So let me ask you, did you check Facebook and Instagram? Because I'm sure whatever they were doing was posted.
Well, they smart enough to have all the key blocked on there. So you can't find no information. You can't see no status. You can't see nothing. They've been laying low. Whatever they've been doing, they've been.
All you had to find out is from work who was connected to them, who was their friend. And trust me, they've been able to show you the pictures. Yeah.
I had a situation like that. There was an employee who actually took 4 weeks, they took a month vacation from their current job and came on the job to work just to feel it out.
Of course, yes.
If they wanted it. And
I've heard of that, yes.
And in about 2.5, almost 3 weeks, they resigned from the job because they said it wasn't what they expected. And when we saw them again, they were still employed with where they were. And come to find out they were only on vacation. And so fallacious, I think that person may have already been on their new job and they just
But listen, I was trying my hardest to find out.
Went on a cruise.
If any contributions was coming from someplace else. I was dying to find out, but I was just like, okay, I wasn't able to.
That's a big move right there.
I mean, I don't have, I mean, even this might sound good for my job, but I wish sometimes if I get an offer, if I could take a leave of absence or something.
Just to try probation, right?
Check it out.
Just
go try it out, and if it's making no sense, come back home. But
that's what the young
man you're only human. We forgive you. You only human.
I wish.
The young man did, but that's what the young man did. He took vacation and he went somewhere else to work. And then in about 2 weeks, he realized this ain't working. So what happened? He would have gotten paid for those 2 weeks. He showed up.
That's right.
And then when he resigned and he moved back to where he was like, boy, good thing I didn't leave. And so he got his vacation pay from them and still got his 2 weeks pay from where he went.
Well, he was smart. I mean,
Are you serious?
Yeah,
Miss Archer, that's these young people for you now.
I know. You will find out. You'll find out in HR now if you don't have any type of done any type of psychology training, you need it.
Yes.
There's a different breed of employees. Different breed.
And
I know
they just approach everyone different. They approach the females with that sickness and family part. And if it's
they
a
know how to
male,
play
they're
on you.
approaching.
And
Yes,
it comes
and if it's a
natural.
male, they approach the male from some relationship or family part.
Yeah.
I saw that.
You don't forget now, these are people, they're not like how, like from my age group is, where everything I learned would have been from books. I would have finally come into the internet when it started. Still don't have much time for the internet. These people know the internet. They know Google from when Google started. They
They probably started it.
Yeah, they started it. They know what it is. They know how to maneuver. They know how to hide and duck. They know how to do that.
Hell yeah. Yep.
Okay,
Yeah.
so if you went on the basketball court now, let's just say you were physically fit at the age of 50 or 55 or even 45. You went on the basketball court now with someone who was between the ages of 18 to 26. You probably have a heart attack. They'd be ducking and dodging all around you. You would wonder what they doing. They'd be saying, but you don't know this move. You move your hand this way now, not that way. Put it up, bring it down, can't to the back. They know everything they know. And they learned it from on the computer.
And you know what I noticed too, Miss Archer? It seems like the workplace is hiring more of them.
Well, they're trying to get rid of the old people like us because we work using the brain. They want you to use artificial intelligence. So the intelligence is in the computer and that's what they follow. So they'll tell you sometimes when you call certain places, they'll key it into the computer and they say, no, I cannot help you. It's not here. It's not on the screen. They're not going outside that screen.
Yeah.
Because that means they have to think and I'm not being paid enough to think.
Didn't I tell you every time I called, it wasn't you, I told Miss Dorset when we were trying to answer some questions, she asked us to do for homework. You call the people and you ask them and they tell you, oh, we'll go to the website. And I'm like, well, everything isn't on the website.
Since they upload the website.
Thank you. And I told them the information is in there. They send you to the website because no, but I don't know this. I'll have to get so-and-so to call you back. And I'm like, oh.
But that's what they've been trained to say, and they're not going outside of that.
Yeah.
I do not try to give them any other duties that is going to extend to them having to use their brain. Because their brain is not for that. It's to party and dress up and whatever else. But they're not going to do it. If you pressure them, they will quit.
Just for clarity, what age group is this again?
The youngest one.
Tehran, it's not you.
I have to make sure I ain't getting caught up in the rapture.
Tehran, it's not you.
Just making sure.
This is the new era, the new workforce.
The Gen Z.
Yeah, okay, that's definitely that.
I think millennials safe.
Well, kind of. Somewhat.
I feel like the millennials are the future.
Really?
We in between everybody, so we gotta deal with
what?
Well, then.
Well,
when they get rid of the baby boomer child, God help you all.
That's right, and I'm one of those baby boomers, and I'm
a
in
baby
the last
boomer.
leg of that.
I am telling you.
When
you see me over,
yes.
You all ain't gonna, you all, but the life you all live will never be nothing. They would never live a life that what? You see the way the world is today? We never live like that.
No
way. I told a young man at my office, he asked me a question the other day and I had to tell him, I said, sweet boy, I say, you all will never know what it was like to grow up in our era. Okay?
They wouldn't survive.
No.
They wouldn't survive.
When we had the pandemic and you had to stay inside, I mean, my grandchildren was like, they was going crazy.
Yeah, they have to get out.
Yes, and my son, I had to tell him, I said, boy, you bring COVID here, I'll kill you. It's like, he had to go party up to a certain point before he come home to be locked down. I'm like,
Yeah, they couldn't stay inside. They couldn't take that confinement.
and one evening I came home and it was like his whole crew is gonna be spending the weekend. I tell him they go where they said social distance, not bring the people in here. You let them go where they live and you stay where you live. They were doing some strange things. I'm not
Oh, yeah.
lying.
They found some crafty ways to be on the road, traveling with receipts and grocery bags and.
Oh yeah, they made them up.
My
Very
son
crafty.
said he's an essential worker.
Oh,
Well,
yeah.
it's the same way they all now creating their own booster cards and COVID card. They will do whatever but they're not putting anything in their bodies, like if they know anything about a body.
Mhm.
No, but
Wow.
it's serious. Their mind is set that they're not putting anything in their body. They're not doing it. They will never do it. But what are they talking about? When they were born, they were vaccinated.
Mhm.
Hello, we made sure of it.
But they said
But-
that wasn't their choice. They now have a choice and they're not doing it.
I'm telling
Mhm.
you. But we have this new, like I said, with them bringing this new set into the corporation now, we feel so out of place because they act differently. They come to work, their little skirt up, their little behind. They got the nails long, like they go into a vampire movie. All kind of things. And we're like, what's going on? And it seems like it is accepted.
It has to be accepted because they are the new generation. They are the new workforce.
Let me try go to work with one little piece of skirt up my behind. What you think they'll tell me?
Well, actually, where you come from, go back home.
You understand? But and I telling you, they come in and all kind of weave down to the back of their legs and
yes.
What I can say, and let me be a little on the other side, I do appreciate the younger generations, their strong-mindedness. If they are unhappy, if they tell you they're not doing something and it makes them uncomfortable, they mean that. They don't have no problem walking away from the table if they are not going to be unhappy, and no employer is going to make them unhappy. And I think for the older generation, because we have so much responsibilities, we will sit and be unhappy for years and years and years. They will say, okay, I'm out of here, whatever. I'll just have to find something else. They don't think about that, but I mean, I admire that a little bit, that they stand up for themselves. They certainly do. So
they're very self-confident.
but I'm not saying that they don't bring things to the table, right? Because I know, like when they first introduced the computers, I'm a woman who was typing on a typewriter. They don't know a typewriter, and I'm learning a computer. So we learn from each other. But there are some aspects of them.
Yeah, well, you ain't gonna take advantage of these young people.
Hell no, they can let you know. What?
Trust me, you're not.
My grandson wouldn't let me do that.
So when I started the job, the older ladies, they say, we came in walking on 2 foot, say, but y'all young people look like y'all coming in on 4. And they say, and so now I'm at the point, I say, these said look like they coming in on jet ski.
Yeah.
That's how much it's changed.
It's changed, yeah.
But like I said, it's not bad because we learned, but I wouldn't say I learned from them, and I really appreciate that they find me to ask questions about things they don't understand, and anything I don't understand, like when that computer playing crazy, child, I call one of them young brains and I say, come. And like I said, we draw from each other, but like I said, the culture of them, some of them know some of the stuff that they bring to the table isn't all good.
Yeah.
But they're not all bad.
Yeah, I came up under that generation that you just had mean bosses and you just had to keep quiet and
do your work, pay your bills.
Just accept this is how that person is. But you can't mistreat any young person, the majority of them, I would say. You're not going to speak to them any kind of way. You're not going to disrespect them. You're not going to take away any rights that they show that they have. And
we under union too, so we don't do, that's not how we act at the corporation. Mind you, you do have some people who have that kind of mentality, but for the most part, that is not how we operate, because first of all, they will go to the union for you. You ain't gonna pull that on them, and they just know that they didn't know that little blue book, the industrial agreement, better than some of us.
And that's how they operate. Okay. So job abandonment got y'all very active. Get like the young people now. So termination of employment and effective notice. So under common law, an employer may dismiss an employee for any reason he chooses or no reason at all, provided he gives reasonable and adequate notice to the employee. And if the employee fails to give the notice or gives it unreasonably or inadequately, then he may be sued by the aggrieved employee for damages for wrongful dismissal, subject to certain exceptions in law. So they says that on termination, there are two questions that need to be asked and answered. Whether or not the employee was entitled to a certain period of notice, and whether the employee's conduct amounts to gross misconduct or conduct which attracts summary dismissal and therefore no notice at all. If a contract of employment is for a fixed term, then it automatically terminates on expiration of that fixed term and no notice is necessary, unless there is a provision in the contract which requires notice on early termination. So an employer must give reasonable notice to an employee before terminating his contract of employment, unless he terminates on the ground of misconduct. What would amount to reasonable notice and the requisite length of time of notice are dependent upon the facts in every case. However, where reasonable notice is not given by the employee, he will be required to pay salary or wages in lieu of notice in accordance with the Employment Act. So under common law, reasonable notice requires some consideration of several key factors relating to the employee. You're looking at seniority in and the length of service with the organization, looking at experience, the health of the employee, the chances of alternative employment, mode of payment, position, duties, and responsibilities, among other factors. And so in HR, these factors you have to bear in mind, especially reasonable notice. So it's not saying, okay, we're gonna let them go now, and based upon their years, we have to pay them 2 weeks, or we have to pay them 3 weeks and 4 weeks. There are other things you have to take into consideration, such as the person's health, whether or not the person, how long will it take for the person to find alternative based upon their position in the company. Look at their duties and their responsibilities. There may be certain things that you don't want them to share with other, with competitors. So all into the package when you decide that you're going to terminate a relationship with an employee. So it is critical to remember that the determination of reasonable notice is driven by a thorough analysis of the facts of the case surrounding the employment, the status and prospects, and determination of the employment of the aggrieved employee. And then I give you a few cases. So under Section 29 of the Employment Act, the minimum period of notice required to be given by an employer to terminate an employee is where the employee has been employed for 6 months or more, but less than 12 months, 1 week's notice or 1 week's basic pay in lieu of notice, and 1 week's basic pay for the said period between 6 months and 12 months. Where an employee has been employed for 12 months or more, 2 weeks notice or 2 weeks notice basic pay in lieu of notice, and 2 weeks basic pay for each year up to 24 weeks. An employee shall not terminate his employment until after the expiry of 2 weeks notice to the employer if the employment period of employment is 1 year or more, but less than 2 years, or 4 weeks notice to the employer if the period of employment is 2 years or more. So I know of an instance where the contract said you had to give 4 weeks notice, but the employee had not been there for 2 years. So the employee gave 2 weeks notice. What would you do in that instance?
They're right.
Mm-hmm. By law.
It's Archer, good, this is a good thing. This is a good question because I'm in this situation right now. And I was gonna ask this when we got to this part, so it's a good question.
Of course, because it is an internal policy, whoever the person's in management would have to say that they are granting a waiver to that policy. But the law states that that is the time that you have to give notice.
And the law trumps that.
Where I was just gonna say where there's an industrial agreement that speaks to 4 weeks notice, but the Employment Act speaks to 2 weeks. The Employment Act trumps the IA, right?
Yeah, so what you normally do as a formal process is management would then say, we hereby permit the person to leave for 2 weeks. We grant an exception to the policy.
I've actually been challenged by persons who want to resign, employees who want to resign on the requirement that they give 4 weeks notice, and I have to refer them back to this. I've had 2 challenges on that so far. You know, just
Right, yeah,
read the law.
yeah,
Yeah.
that's it right there.
And the other thing too is that if I've had a case where the employee gave, 3 days notice. And mine, he backdated his letter to make it look like it was written 2 weeks ago, but he didn't submit it until 3 days before his resignation date. And so the compromise to him was, well, we'll just wait out the notice period you should have given before we give you your final pay.
Yeah, yeah. He was one of those new generation, eh?
Yeah.
Yeah.
Well, actually, in his case, the thinking about him, no, he wasn't. And that was what I found surprising. So it tells me then he got something else and just forgot to turn in his paperwork to us.
Yeah. He's too excited.
So Ms. Archer, I just want to get an understanding. So it'll then be at the discretion of management to accept the 2 weeks notice from a person that wants to go because even though they wouldn't have put in the 2 years, it's management's discretion?
But normally, yes, because they have in their contract, they would have written that you have to give 4 weeks notice. You signed a contract.
Yes.
Which is binding. And so even though the law says 2 weeks, the contract will trump that.
Yeah.
The contract
because you
trumps
signed.
the
Yeah, because you
Employment
signed that.
Act?
Yes, you signed that.
Wow.
Okay, okay.
Because that
Yeah.
binds you regardless of what the law
Yeah.
says. You sign that contract that binds you to the term. So
Oh, okay. Wow. All right.
So your contract says 4 weeks
Yes.
and you want to
You must
leave.
give 4 weeks notice in the event of resignation or termination of employment.
But that's tricky
So
though.
you'll have to pay them 2 weeks.
But that's tricky because how can you say that the contract would trump the law in this instant? But can I sign a contract and if the contract is less than what the law is, can I give an employee a contract to say that I'm going to pay them less than minimum wage? And if they
No, you
No.
can't.
that's
No,
different.
that's different.
okay,
But
so
remember your contract of employment outlines the term between you and the employer, regardless of what the law says.
No.
yeah, but what I'm saying is if you agree to accept less than what the law says is minimum wage, and then but I'm telling you have to give more than what the law
No,
says.
but you see what you see that key word there's minimum. Minimum, the lowest.
Yeah.
Okay,
can't
so
go below it.
so what the law doesn't say in terms of notice that it's a minimum. It's okay, so it's a maximum of. I'm confused here. If I've been employed for less than 2 years, I have to give a minimum of 2 weeks.
2 weeks notice. But
Notice.
but
But
your
you're
contract says 4 weeks and the company's policy is 4 weeks.
And you sign that binding agreement.
Right. It's the same as if you got a job as a CEO.
Mhm.
You got a job as a CEO. In that contract, they had a garden leave, saying that if you want to leave, you have to give us 6 months notice.
Mhm.
You cannot give them 2 weeks notice.
No. Okay. Okay.
Because the court will look at it and look at your position, your duties, your responsibilities, what you're being exposed to, and they're gonna say no.
Yeah.
How long would it take for them to replace your position? That's just no, you can't do that.
Okay.
And that actually makes sense when you think about the term reasonable notice, because if the scenario that you just gave, Ms. Archer, you're not the CEO, you are, say, the custodian, and your contract reads you have to give 6 months notice, that would be considered unreasonable because your position is not one that would greatly impact the company should you leave in 2 weeks or 4 weeks.
Yeah. Okay.
Okay. So under section 30 of the act, the notice of termination by the employer to the employee may be given orally or in writing in person to the usual or the last known place of address, sent by a prepaid registered post addressed to him at that place. And likewise, any notice of termination given by the employee to the employer may be done in the same manner. Now let's go to redundancy in the Amendment Act. An employer, that's section 26, an employer may lawfully dismiss an employee because of redundancy, provided that the provisions of this part are being complied with. So an employee shall be deemed to be dismissed because of redundancy if his dismissal is wholly or mainly attributable to the fact that his employer has ceased or intends to cease to carry on the business for the purposes of which the employee was employed by him, or has ceased or intends to cease to carry on the business in the place where the employee was so employed. The fact that the requirements of the business for employees to carry out work of a particular kind, or for employees to carry out work of a particular kind in the place where he was so employed have ceased or diminished, or expected to cease or diminish. Provided that an employee should not be deemed to be dismissed because of redundancy, where such employee is required to carry out work for a fixed term of less than 2 years in respect of a specific construction project, and such time has come to an end. So what's the obligation of an employer who is contemplating redundancy? They say where it is contemplated by an employer that 20 or more employees are to be dismissed because of redundancy, prior to dismissing those employees, the employer shall. So you see, the law gives you an amount, 20 or more. So of course you can start to make them redundant by 2 or 3. It says 20. The employer shall inform the trade union recognized in accordance with Part 3 of the Industrial Act, or if there is no trade union, the employee's representative of such contemplation, and provide a written statement with the following particulars: the reason for the dismissal contemplated and the facts relevant to those reasons, the number and category of persons likely to be affected, and the period over which such dismissals are likely to be carried out. So this is the formal process where a letter is written to the Ministry of Labor and advising how many persons are to be made redundant and why the redundancy is taking place. So not later than 1 week prior to any employee being dismissed, consult with the trade union or the employee's representatives on the possible measures that could be taken to avoid or mitigate the adverse effects of the redundancy, including but not limited to an offer of re-employment in accordance with Section 26C. The appropriate method of selection of employees to be dismissed because of redundancy, taking into account seniority, the needs of the business, and the principles of good industrial relations practice. The procedures for dismissal, including the period of time over which the dismissals are to take place. So you would have seen in the news the good relations that happened between the Hilton, the British Colonial Hilton, and Breezes. Any measures that the employer might be able to take to find alternative employment for those who are to be dismissed because of redundancy. Then they have to consult with the minister in writing no less than 2 weeks of the contemplation and give the reasons for the dismissals, the number and the category of the employee to be affected, and the period of time over which the dismissals are likely to be carried out. So notify the affected employees in accordance with Section 26B after all consultation referred to herein have been concluded. So you see the law sets out an actual process that you have to go through when you're making employees redundant. And that's why you saw in the papers there was so much talk over the Hilton and trying to find placements for those employees.
That was an awesome exchange between them and
Yes. Yes, it
Between
was.
Hilton and Sandals, yeah.
yeah,
Mhm.
it was an awesome exchange.
What was the final outcome? How much of the employees were able to be placed? All?
I don't remember them saying in the newspaper.
I
They ain't
know,
complaining, so it must have been a large amount.
yeah, I know
Yeah.
Sandal said that they would take on the majority of them, but I didn't know Breeze was included as well.
I'm
Yeah, I
looking
know, but
now. to see.
Sandals, I didn't know about the Breezes one.
The sandals, I meant sandals.
Oh, okay. Well, they opened up just in time. Maybe that was a collaboration.
It's a collaboration because, like I tell you, the process is you have to go to the Minister of Labor and you have to have a discussion. So even though you're going to write this letter, you're going to meet with the minister and you're actually going to discuss your whole redundancy plan. And of course, the minister would be privy to another employer seeking employees. And so they have to bring the two together.
Well, that was awesome because I had no complaints, so it must have worked perfectly.
Okay, so it says here that the Department of Labor is partnering with the management of Sandals to ascertain how many of the 106 and remember that I think they said they needed how many hundred of people?
I said like 400, I believe.
Yeah, so most likely they probably took all of them.
Yeah, because the guy was saying he was hoping they could start the next day.
Because they were looking to fill Nassau, Exuma, and Fauki.
Well, that means that those employees
three
that paid
hotels.
off from Compass Point should have also gotten some of that. Then they wouldn't have been disenchanted by that. Disenfranchised, sorry.
Yeah, how many of them were there?
I don't think it was that many though. I probably was 100, maybe less.
If it was 100, then they should have done the same thing.
I think persons were leaving from the dispute started.
Let's see. I'm gonna looking for Comfort Suites.
No, Compass Point.
Compass Point.
Yeah.
Let me see if anything was in the papers. No, they were not in the paper.
Okay.
Compass Point situation was a little different, and they was having a disgruntled battling.
No, I'm saying the employees would have been able to find the placement at other areas because of the opening of Sandals at that particular time. And them needing so many employees. So the fallout I'm talking about shouldn't have been as bad.
Yeah, I got what you mean, but I don't see anything in the papers.
Okay. But that would not have been a collaboration. I think that's what Palacios is referring to. That wouldn't have been a collaboration.
Yeah, I mean, and I think that their number, I actually was to Hilton before I came at the board, and the staff complement was about 300. So for the last few years, they had kind of been planning for this. So it was no surprise to most of the staff. So to 106 left, they were just, I guess, holding on.
Until the doors closed.
Yeah. Mm-hmm.
Yeah. So, but that was a good collaboration, though.
Yep.
Yeah.
So when an employee has been section 26B, so when an employee has been continuously employed for 1 year or more, and if they are dismissed because of redundancy, his employer is liable to pay him a sum calculated in accordance with subsection 2. So the amount of the redundancy payment shall be calculated by reference to the date of the employee's redundancy by starting on that date and reckoning backwards the number of complete years of employment, and allowing where the employee has been employed for 12 months or more, 2 weeks notice or 2 weeks basic pay in lieu of notice, and 2 weeks basic pay for each year up to 24 weeks. And where the employee holds a supervisory or managerial position, 1 month's notice or 1 month's basic pay in lieu of notice, and 1 month's basic pay for each year up to 48 weeks. So notwithstanding subsection 1, the employer shall have the right to appropriate any monies owing to him by the employee from any monies payable under subsection 1. 6C says, where as a mitigating measure for the situation of redundancy, an employer has made an alternative offer in writing to an employee to renew his contract of employment or to re-engage him under a new contract, so that in accordance with the particulars specified in the offer as to the capacity and place in which he would be employed and the other terms and condition of his employment would either be the same as the corresponding provisions of the contract enforced immediately before his dismissal, or differ wholly or in part from the corresponding provisions of the contract as enforced immediately before his dismissal, but the offer constitutes an offer of suitable employment in relation to the employee. The renewal or re-engagement will take effect on or before the expected date of redundancy, or not more than 4 weeks after that date. So priority to redundant employees on rehiring. When an employee is made redundant in accordance with section 26 and within 12 months from the date the employee was made redundant, there is an increase in demand for such goods and services. An employer has to recruit employees for the purposes of the business. The employer should give priority to the employees who are made redundant. And the presumption against genuine redundancy and sham arrangements. An employer shall not dismiss or threaten to dismiss an individual who is an employee of the employer in order to engage the individual as an independent contractor to perform the same work. Where within 12 months of being made redundant by an employer, an individual is engaged by the same employer or his agent to perform the same work that the individual did in the previous employment of that employer, the contract shall be deemed to be a contract of services unless the terms and conditions of the contract are more favorable to the individual in the new contract. So payment of redundancy shall be made on or before the date of the employee's redundancy. Redundancy payment may be recovered as a debt due to the employee in proceedings before the tribunal, and a redundancy payment shall be preferred debt in all cases involving bankruptcy or liquidation.
Excuse me, Ms. Archer, where were you reading from just now, please?
27B. Page 6 of the amendment.
Oh, because I was gonna say, I didn't see anything speaking to redundancy in my notebook from the institute.
No, you don't. They're reading it from the actual
Okay.
act. So unfair dismissal.
Jumping between so much different stuff. Okay, thanks.
You between too many different stuff, eh?
Yeah, I was jumping between, the book, the employment act and online with this, the update, the amendment. Okay.
So you don't sound like a baby boomer, so you should be able to keep up.
Ms. Archer, I have a question. I have a question on 27A2. In the event an employee was made redundant, is this reading that if they are re-engaged in less than 12 months to do essentially the same job, it's considered then there's been no break in their contract?
Yes, ma'am.
That is interesting. Okay.
Mm-hmm.
Because it actually.
Then don't forget now, the interpretation of that section will have to be challenged in court.
Who would challenge it?
Any employee.
No, well, the reason why I'm asking is because we've had a situation like that when we had redundancies through COVID and the school was closed.
Mm-hmm.
There were 2 cases I'm aware of where persons who were made redundant, they were found to be back on campus working as subcontractors. And I just question, wait, what? But this actually adds some clarity because that employee could then have approached HR and said, my contract of service to you was never made redundant because I was brought back within a year to do the exact same work.
Same work, yes.
Yeah. Okay. It just opens your eyes as to how decisions by managers can absolutely affect the company without, without collaboration on how and why. Like, why did this manager bring this person back? Because we could have guided them.
Mm-hmm. Mm-hmm. And see, and lots of times, sometimes HR not a part of those conversations. And that's why I always, when students come in from HR, I always say sometimes it's good to send your managers in.
Yes.
And if okay, let's just say from your place of employment, anybody place of employment, they say we have a team of managers, we would like to send 4 of them. A concession can be made in terms of maybe the case studies may be a little bit too heavy for them. You see what I'm saying? Because they're not really in HR per se. So they will go through they'll go through the same things that you're going through. But then for the exam purposes, we'll have to write the exam a different way. Whereby they won't be referring to cases as that, but they will get the basic understanding of what employment law is all about. Because we do have an introduction at BIFS for an introduction to HR.
But I did this, I did a touch of it when I did my my business admin degree.
What?
Right.
What?
But a lot of them don't have that exposure.
Huh?
And they'll just be making decisions on what they need. And even sometimes when HR tell them this is what the law says, they're gonna push back.
Because they don't really know.
They don't really
Or they
know,
can't
they don't
explain,
understand.
they can't explain it. Now,
No.
now Palacios was she was talking about the employee coming back as a independent contractor. It may have been because they may have paid that person when they made them redundant, they may have paid them everything. And maybe they might want them starting off so they don't have to be bound by having to give them benefits and all these things after they've already paid them all this money.
Yeah, but what that has to do with the price of tea?
Well, the person obviously doesn't know that they could have gone back and said something about it.
Of course, you're right. They didn't know.
Right. And that's what she was saying, that maybe they could have guided them differently.
I know, but they didn't come to them because they didn't. The first thing is they may not even have been aware that there is a law on the books.
Right.
Right.
And then like she was saying, that puts the company in jeopardy now. Because let's just say a member in this class now is reading this and saying my uncle or aunt, this happened to them 2 months ago. Then it puts the company at jeopardy because now the person will want to sue.
Right. Just like how I'm trying to help my nephew. Like I tell you, this is so interesting. I mean, I think even if you are not in HR, I think everybody should know this, and that way employees wouldn't be taken advantage of anymore in this country, because I find that is happening, and you hear me say it all the time. The labor laws are being broken in this country over and repeatedly. And so if people are aware of this, you don't have to really know it for any other reason than to know it to protect yourself. I think it's very interesting.
One other question that I had, despite or as this likes to use, notwithstanding that the company has paid the redundancy pay to the employee who was made redundant, and then employee then challenges because they were brought back to work as a subcontractor for essentially the same job, that the fact that the company made the redundancy pay is no protection to them of what is now. Yeah, that's their loss.
Yeah, that's their loss.
The company's loss. Yes.
Because if the company had sat down with HR and stated what they needed during that pandemic period, then they would have known which employees they should have kept on as a skeleton crew.
Exactly. The company ought to have known the conditions under which redundancy would have affected them.
Yes.
Okay.
But see, that means then that they don't have an effective HR department then.
No, if they didn't consult.
Exactly.
You need to consult.
Well, effectively, they would have consulted if they had been effective.
But you know where the error was? It wasn't so much in the making of the redundancy. It was the decision of the hiring manager to rehire this person without consulting. That's without
consulting HR. Yeah.
Correct.
But you know, like you say, consultation is important, because just like how we have a union for the staff, and we have and we collaborate with the union when it comes to issues with them, I find that we have a consultant that they deal with the managers, or they deal with other corporation matters. They don't just go into HR and make a decision. They call their consultants in, and then they collaborate with that person, and them together make a decision. And so I know that for sure, that you should have a consultant, even though you have an HR department. Yeah, we have a consultant, somebody who comes in like on the corporation's behalf, to make sure that HR is within the law when they make their decisions.
More expense.
But they do have somebody.
Yeah.
And I think it makes sense because it costs you more if you do something on and have to go to
Oh,
court.
yeah. So it's an added protection.
Yes.
Ms. Archer,
Mm-hmm.
just a quick question, something that I've been laboring over. What if an employee resigns? Do we have to take that in? We have something, I'm from the police. There is a clause where they say once you leave, you have within a year to return, right?
Uh-huh.
A lot of our officers are of the view that that is mandatory. Now, the question that I have is, if a person leaves, they usually get their benefits and they would have already gotten their benefits. Let's just say for some reason they're brought back in. We do take them back within that year, right? I know you said that if they're doing the same duties, their time should
But
not.
that's redundancy now. Don't mix up redundancy from resignation.
Okay, very well. Thank you.
Okay.
Just wanted to be clear.
Yeah. That's different. Okay. Yeah, see, y'all like this section. Oh, I should just write all my exam questions on this chapter.
Yes.
It's very interesting.
Yes, it is. So, unfair dismissal. That's sections 35 to 40 of the Act outline the circumstances under which a dismissal is considered unfair under statutory law. So under section 36 of the Act, dismissal is deemed to be automatically unfair if the reason for it was or were that the employee was or proposed to become a member of a trade union, had taken or proposed to take part of an appropriate time in the activities of a trade union, or was not a member of a trade union or a particular trade union, or was one of a number of particular trade unions, or had refused or proposed to refuse to become or remain a member. So the aforementioned reasons are considered inadmissible reasons. If the reason for the dismissal is an inadmissible reason, then the employee may report the matter to the Minister of Labor under the provisions of the Industrial Relations Act. If the principal reason for dismissal is redundancy, and there is evidence to show that the circumstances relating to the redundancy applied equally to another employee or other persons were not also dismissed, then the dismissal is deemed under unfair, particularly in instances where the selection of the dismissed employee was based on an inadmissible reason, or the employee was selected in breach of an agreed redundancy procedure, or there were no reasons to depart from this procedure. Under section 38 of the Act, if the principal reason for a female employee being dismissed is her pregnancy or any reason relating to a pregnancy, then that amounts to an unfair dismissal of that employee. Consequently, an employer who dismisses a pregnant employee must demonstrate or prove that the dismissal of that employee is in no way related to her pregnancy. Dismissal is unfair in a strike action. And you know, NIB was just on a 3-day strike. If only some strikers are dismissed and other strikers are not dismissed. In the event of a lockout or industrial action, a complainant to the Minister of Labor must show that another employee who participated in the lockout or the industrial action has not been dismissed, or another employee who has been dismissed for participation in the action has been reinstated or re-engaged. An important caveat that is found in section 40 of the Act is that an employer is entitled to dismiss employees participating in a strike, which is in breach of the law, provided that he dismisses all of the persons who participated in the strike and does not reinstate or re-engage any of them. The employer must dismiss the strikers while the strike is taking place and not when it is over. Another such employee that has a claim for unfair dismissal is a replacement worker who is dismissed on the return to work of an absent employee with no written notice that his termination will be made on the return of the employee. So where the employer does provide written notice of termination to the replacement worker, that on the return of the absentee employee, he will be dismissed, and dismisses the replacement worker accordingly, then that dismissal will not be deemed to be unfair. So what are the remedies that are available to an aggrieved employee who is unfairly dismissed? You could have reinstatement or re-engagement, compensation, basic award, compensatory award, or an additional award for disobedience of the tribunal order.
Ms. Archer,
Mhm.
what is the difference between the compensation and the basic award?
Oh, now you're going into some real legal technicalities now.
Because I'm thinking if you have compensation, that would be a basic award right there.
No,
Okay,
no.
all right.
You really want to know?
Yes, ma'am.
Yes.
Oh, Lord.
Do
All right.
the quick, fast, and a hurry one.
All right. So compensatory award is an amount that a tribunal considers as being just and equitable in
Okay,
all circumstances.
okay.
So they look at the loss that's sustained by the applicant due to the dismissal.
Okay. And
And
basically
again-
that would be based on like your salary, maybe.
Yes, but more than that, it depends on what loss you sustained.
Okay. Based on your application. Okay.
Yeah, your pleadings. Remember, you have
The
to
pleading,
plead.
sorry, yes, the pleading, sorry.
Yes.
So that would be
So-
considered like losses that the individual employee felt that they suffered from because of this.
Yes, yes.
Okay,
Okay. So a basic award is an award that is made by the tribunal. And that's based on the calculations. So let's just say if someone said, I was unfairly dismissed, but they only paid me for 3 weeks. And the tribunal then says you should have been paid for 6 weeks.
right.
So it's calculated on the statutory redundancy payment.
Okay,
And it's based on your age, your length of service, and your week's pay. And it's
Okay.
capped to whatever the law says. So that's your basic award. So it's
Okay.
whatever the law states that you should get on termination. That's your basic. But
Okay.
compensatory is more than that. It's looking at all of your loss.
right. Understood.
Okay. So generally, an employer must show that the employee was dismissed for one of the following reasons for dismissal to be considered fair: incompetence or incapability, misconduct, gross misconduct or other misconduct, redundancy, or illegality. It's important to note that the burden of proof is on the employer to show that one of the aforementioned reasons was due to the true reason for the dismissal of the agreed employee. Now you could have constructive dismissal, and that's where it requires an employee now to demonstrate that the employer has seriously breached the contract of employment. And that could either be unauthorized or unilateral changes to salary or benefits. Constructive dismissal normally implies a breach on an implied term of mutual trust and confidence under the contract of employment. The burden of proof for constructive dismissal is on the employee, and he must prove that there was a serious and repudiatory breach of contract by the employer. His resignation was as a result of the breach, and the employee did not waive the breach by continuing to work as normal or contracted. A constructive dismissal may in some cases amount to an unfair dismissal. Any attempts made by employers to induce, coerce, or persuade an employee to resign may also be considered constructive dismissal in certain circumstances. Wrongful dismissal, that
Sorry, Ms.
occurs
Archer,
when,
I'll ask this
Go
then,
ahead.
with what it said just now. What happens in a case where I guess the employer gives the coerce or gives the employee the option to resign as opposed to being terminated? How does that fit there?
but that's not coercing.
That's not them saying, okay, so I guess that's them giving them the option A.
It's giving you the option instead of when someone calls now to HR to say, was this person terminated? And then the answer would be no, because the employer gave them the option of when they were seeking employment for it to be a smoother transition. So they said that you can actually resign. rather than us terminating you. And that normally depends on the level that you are in the organization. It's normally given to management. You either resign or we fire you. Which one do you want?
Right, and if it's for cause, then it's not duress.
Right.
That was my next thing, because like she said, if it was not duress. Okay.
Yeah.
What are some examples of the type of constructive dismissal? Let's say there is an employee that that's not performing to par, but not so much so egregious that you can write them up for it. They just maybe have a bad attitude, or they're unresponsive to your requests.
Now, don't forget now, constructive dismissal is the employee asserting this now.
Right. So what evidence would the employee have to give of the type of actions by the employer that would imply constructive dismissal?
Then he's gonna probably, if he was taking note of conversations that he had, either with his supervisor, manager, or with HR. Because there's not going to be anything in writing.
Right. What are some of the things that, like the examples that he could demonstrate that were indications of constructive dismissal? Increasing what, workload or responsibilities, or like what are the kind of things?
Yeah, it could be workload, it could be responsibilities, it could be changing the benefits without having a discussion, changing his salary, anything that's done unilaterally. That's what constructive dismissal means. The employer made changes to the terms and condition of the contract without consulting with the employee.
Okay.
Yeah. So wrongful dismissal is when an employee is dismissed without notice, or where notice was given and the notice was inadequate.
Like my nephew, right?
Yes. The employee is usually entitled to reasonable notice if his employment is terminated without cause. An employee who's wrongfully dismissed may be paid damages for breach of contract as compensation for wrongful dismissal. And this remedy aims to place employees in the position they would have been had the contract of employment been performed as agreed by the parties. The employee may claim monetary loss and other pecuniary loss, such as for housing or tips or any other losses that they would have had been a benefit to them. The claim for wrongful dismissal is essentially a claim for unliquidated damages. However, employees are under duty to mitigate their loss in a wrongful dismissal claim. They must make some effort to find alternative employment after their dismissal. The damages that an employee may recover from wrongful dismissal are based on the remuneration that he would have earned during the notice period if he had received the proper notice and was employed at work during that time. The employee receives damages as compensation in a wrongful dismissal action, not wages or salaries. However, such damages do not include damages for injured feelings or loss of reputation, or the difficulty in finding alternative employment due to his wrongful dismissal. An employee may recover stigma damages, compensation for pecuniary loss due to the loss of reputation caused by an employer's breach of the implied term of trust and confidence. And I know you all did trust and confidence. Summary dismissal. That's section 31. An employer may summarily, yes. An employer may summarily dismiss an employee from his employment without notice and without pay in lieu of notice when the employee has committed a fundamental breach of his contract. So under the act, misconduct constitutes a fundamental breach, and examples of that are theft, fraudulent offenses, dishonesty, gross insubordination or insolence, gross indecency, and breach of confidentiality. And I wonder if those videos that they send around from Atlantis, if those employees are actually fired for gross indecency. You've seen them, right?
No.
No.
No, I know.
I haven't seen any. When this happened?
This has not happened like something that happened yesterday. This happens. They circulate videos of things happening in the restrooms.
Oh, okay.
I've seen them. Gross indecency. Sexual encounters in the bathrooms.
Oh, really?
Of
Yes.
employees?
Yes.
Oh, wow. I've never heard that though.
No, I've
Yeah, that's
seen
what I'm
it.
saying. No, I'm not familiar with that.
No, I've seen it.
Oh, wow.
I've
Well,
seen it.
well, I know the persons in the video can be fired, but can the person showing it be fired?
Well, if you know who it is.
That's
And sometimes
my
you can see, who it is because you see the person who's videotaping it, they're in the mirror.
Oh,
Well, that's the
Jesus.
first problem. What you recording for?
I'm serious.
You record, hold on now.
Archie,
Hold
like
on
you say,
now.
I hope they're all. I hope they're all dismissed.
We're back to that new generation. Of course, you
Yes,
want the videotape for everybody to see.
And they videotape everything. What they eat, what they
Yes.
drink, oh, everything.
Everything that they do. Like, look who I have now.
Everything.
Okay. Let's go to this case of Montine Cunningham and Island Hotel Company. So Cunningham is a former employee of Island Hotel Company, and she was previously employed as an administrative assistant in Security Administration Office. She was responsible for approving and authorizing payment for investigative services by Atlantis of its prospective employees. Additionally, she was responsible for preparing and putting in checks through the accounts department for payment. The Island Hotel Company uncovered invoices put in by FM, an unapproved vendor, requesting payment for services rendered. These invoices caused Island Hotel to approve and pay $298,178 to FM without proper authorization. The appellant gave a statement admitting to the fraudulent scheme, but later said that the statement was made under duress. FM admitted that he cashed the checks and paid the money to the appellant.
Wow.
So once the scheme was uncovered, the respondent fired the appellant, who was eventually tried criminally for offenses of forgery, uttering a forged document, and fraud by false pretenses. But the charges were dismissed by the court. The respondent filed a civil claim against the appellant. The court below found that the appellant owed a fiduciary duty to the hotel, and that FM was an innocent party and not a part of the fraudulent scheme, and that the fraud was not discovered until 2008, and therefore time did not begin to run until that time. The appellant now appeals the decision of the court below. And the court of appeal, they dismiss her appeal. They said that common law, a party to litigation can make an informal admission from which a court can find facts adverse to that party. Based on the evidence, there was no evidence of duress, and the trial judge was right to have so found. Based on the case law, the court is of the view that the appellant's duties at the respondent company impose a fiduciary duty on her to act honestly and for the respondent. The findings made by the trial judge amounted to a fundamental breach of contract, which justified summary dismissal. So let's see why they said that she had a fiduciary duty, because not all employees have a fiduciary duty. So this FM, Mr. Franklin Moss, they discovered that he was an unapproved vendor, and checks, requests for payment to him was services given, of course, by her. The appellant's actions resulted in the respondent approving and paying the $298,000 to Franklin Moss without proper authorization. She gave a statement admitting the fraudulent scheme and said that Franklin Moss was a relative who she asked to cash the checks and pay the money to her.
And he wasn't at fault?
No, not when they went to the criminal charges. The appellant said, however, that she gave the written statement by duress. Franklin Moss admitted he cashed the checks and he gave her the money.
But he knew something had to be up with that.
No, well, she may have said she got something. I don't know, but she would have told him.
That
He
don't
was
even-
involved, $298,000.
And
Yes.
why have to cash it? What happened to go into the bank? Why didn't they give it to you directly?
And from your employer, I don't work there. Why they paying me a check and I must give it to you? You work there. Why they can't put the check in your name?
Send it to your bank account. Why send it to your bank account?
Well, you know, he got something from it. So,
Will he get off scot-free?
Hello.
so she faced 14 counts of forgery and 14 counts of uttering a forged document and 14 counts of fraud. That was in the magistrate court. The court rejected the charges against her, but the respondent dismissed the appellant. So let me move on now. Let me tell you what she used to do. Okay, her grounds of appeal is not that much. Okay, so if you go to page 6, paragraph 12, the appellant contends the trial judge was wrong to find no duress, as Rory Sanders detained her for 8 hours and deprived her of her constitutional right to get legal counsel. She must believe she on TV. Counsel for the respondent at the trial cross-examined the appellant on her of oppression used by the respondent to get the admission. So, transcript question: did you get?
Hello?
All this
It's a
been cost
problem
Miss
for
Archer to
who?
lose. All this
The
been
volume
cost her to
and
lose
all
it.
I was wondering if that was my if that was my side.
Yeah, I guess, yeah.
And then she got to prepare for the next class at 12 anyway.
Well, it's pretty windy out, so maybe something got knocked out.
Shoot, I thought that was me.
That's what I say to her. And I thought it was my system too. You know, me keep saying hello.
Well, obviously it's Miss Archer.
Yeah. Yeah, it looks like she's logged out and probably trying to log back in now.
Okay.
Okay, I dropped. At the juicy piece. Okay. So did they beat you? No, sir. Did they cause you pain? Yes, they did. How did they cause you pain? By yelling at me and pointing out false accusations during the process. What false accusations? They mentioned things I had no recollection of. For example, what? During this process. What things they mentioned? Things in relation to what is written here. Please identify. We weren't there. You were. In question to those checks that were drawn in the name of Franklin Moss, a check request and check. And do you know a Franklin Moss? Yes, I do know a Franklin Moss. I know several Franklin Moss. So the trial judge at her judgment said, there is no evidence that the appellant was kept in subjection or hardship or restrained from leaving the conference room. There is no evidence of any torture, inhumane or degrading treatment, or the use of threats or violence towards the appellant. So from the evidence, we agree with the trial judge's ruling on the absence of duress. Further, the trial judge did not consider the appellant to be a credible or reliable witness. So see, the court didn't even consider her to be a good witness. So she was already going down the wrong road. So fiduciary duties and employment contracts. So she contends that fiduciary duties can arise from an employment contract where there are specific duties and where equity imposes fiduciary duties as well as contractual duties. So where a fiduciary duty exists depends on the person's role. So they cited the case of University of Nottingham versus Fischel and another. Here, the university employed the defendant as a scientific director of its infertility clinic. The university took out an action against the defendant claiming breach of contract by him, undertaking paid work with private clinics without their authorization. They also claimed he was in breach of his fiduciary duty by receiving pay for supplying trained embryologists employed by the university to those clinics. In his defense, the defendant contended that no loss occurred to the university from his failure to get their prior consent, and therefore there should not be an award of damages. The court took the view that usually employment contracts were not normally fiduciary. The court also said that an employee's fiduciary duty not to follow his own interests only arose where the employee was under a specific contractual duty to act only for his employer. The defendant had no duty to tell the university that he was undertaking external work. However, the defendant breached a specific fiduciary duty by receiving payment for directing his trainees to work outside the university for his own interests. The court determined the university can take account of the defendant's profits from the outside of the trainees. So here they quote now, it is important to recognize that the mere fact that Dr. Feschel is an employee does not mean that he owes the range of fiduciary duties referred to above. It is true that in Attorney General versus Blake, Lord Wolf, giving judgment for the Court of Appeal, said that the employer-employee relationship is a fiduciary one. But mainly, the court was not thereby intending to indicate that the whole range of fiduciary obligation was engaged in every employment relationship. This would be revolutionary indeed, transforming the contract of employment beyond all recognition and transmuting contractual duties into fiduciary ones. In my opinion, the court was merely indicating that circumstances may arise in the context of an employment relationship or arise out of it. When they occur, will place the employee in a position of a fiduciary. You understand what they mean by position of fiduciary?
No.
Okay, so when in a contractual engagement, if you are a director of a company, just by being appointed a director, it places you in a fiduciary position. And a fiduciary position means that there are certain duties that go with that job. And those duties are inherent in that job. A duty to act fairly, a duty to treat your employees fairly, a duty of no conflict, a duty not to have secret profits. Those are inherent in that position because it is a fiduciary one.
Are they documented?
No.
Or these are just
that's why it's
that,
called inherent.
Okay, I was gonna say, okay. And once
Yeah,
I learn, you gotta learn the meaning of the words.
Yeah, so when you become a director, it doesn't say in your contract, these are your duties.
It's an unwritten rule, right, Ms. Archer?
It is an unwritten rule.
Okay,
It says
okay.
once you become a director, you have a fiduciary duty. And that word fiduciary is defined still. That tells you what you can and can do.
Ms.
And a
Archer,
duty. Go ahead.
the responsibilities of the employee, when we go back to the contract, it says that one of the responsibilities of the employee is not to have personal gain from the job that they have. So inherently, there is a fiduciary duty built into that, correct?
Or for that one.
Yes.
For that duty.
For that duty, yes. And that's
for that duty.
One of the what's the word I'm looking for? One of the pillars on which the contract is built.
Right. Because that also falls in line with your duty of loyalty.
Yes.
So that's why I say now, remember I said at the beginning of class, you have to tie in from the first half of the class. It comes here into this part now. When you're talking about dismissal, you're talking about resignation, suspension, you have to look at what's the duty of the employee, what's the duty of the employer. And then there are other situations that arise, such as this one of a fiduciary duty.
Okay.
So on page 9, Lord Brown Wilkinson recently observed in the case of Henderson that the phrase fiduciary duties is a dangerous one, giving rise to a mistaken assumption that all fiduciaries owe the same duties in all circumstances. That is not the case. This is particularly true in the employment context. The employment relationship is obviously not a fiduciary relationship in the classic sense. It is to be contrasted with a number of other relationships which can readily and universally be recognized as fiduciary relationships, because the very essence of the relationship is that one party must exercise his powers for the benefit of another. Trustees, company directors, and liquidators normally fall under this fiduciary obligation because they have what is termed a fiduciary office. And as he pointed out, typically there are two characteristics of this relationships. Apart from the duty on the office holder to act in the interest of another, the first is that the powers are conferred by someone other than the beneficiaries in whose interests the fiduciary must act. And the second is that these fiduciaries have considerable autonomy over decision-making and are not subject to the control of those beneficiaries. So he's talking about in a trustee relationship. The trustees have a fiduciary obligation, but the beneficiaries do not dictate to them what they should do. So he says, by contrast, in the essence of the employment relationship is not typically fiduciary at all. Its purpose is not to place the employee in a position where he is obliged to pursue his employer's interest at the expense of his own. The relationship is a contractual one, and the powers imposed on the employee are conferred by the employer himself. The employee's freedom of action is regulated by the contract. The scope of his powers is determined by the terms, express or implied, of the contract. And as a consequence, the employer can exercise considerable control over the employee's decision-making powers. This is not to say that fiduciary duties cannot arise out of the employment relationship itself, but they may arise not as a result of the mere fact that there is an employment relationship. Rather, they result from the fact that within a particular contractual relationship, there are specific contractual obligations which the employee has undertaken, which have placed him in a situation where equity imposes these rigorous duties in addition to the contractual obligations. Where this occurs, the scope of the fiduciary obligations both arise out of and is circumcised by the contractual terms. It is circumscribed because equity cannot alter the terms of the contract validly undertaken. So it follows that fiduciary duties may be engaged in respect of only part of the employment relationship. And this was recognized in other cases. So a person may be in a fiduciary position, co-add a part of his activities, but not core other parts. Each transaction or group of transactions must be looked at. So it says in the case of Helmet, it is commonplace to observe that not every employee owes obligations as a fiduciary to his employer. An employee owes an obligation of loyalty to his employer, but he will not necessarily owe that exclusive obligation of loyalty to act in his employer's interest and not in his own, which is the hallmark of any fiduciary duty owed by the employee to his employer. The distinguishing mark of the obligation of a fiduciary in the context of employment is not merely that the employee owes a duty of loyalty, but of single-minded or exclusive loyalty. The distinction between the duty of fidelity, which every employee owes, and a fiduciary duty which requires an employee to act solely in the interest of his employer and not in his own interest, still less the interest of anyone else. Care must be taken not to equate the duty of good faith and loyalty owed by every employee with a fiduciary obligation. So he said in this case, the appellant contends that she did not owe a fiduciary duty to the respondent as she was not a manager, shareholder, or director, but simply an administrative assistant. She also contends the respondent supervised her duties. On this basis, she argues that the trial judge's findings that she was a fiduciary was an error. So the court then says, let's look at what her duties were. She was responsible. She was not solely responsible for any of her duties. That's what she said. As she shared responsibilities with others. She said she denied that she was the last custodian of all authorized checks. Further, it is denied that the appellant owed a fiduciary duty to the respondent, and the respondent is put to strict proof thereof. So she put everything back to the hotel to prove that she had a fiduciary duty. So the duties accepted in her amended claim were: she was responsible for, inter alia, ensuring approval by the Vice President of Security, Mr. Douglas Hanna, of invoices received from vendors for investigative services carried out for the Atlanta Security Department. Following the authorization of the invoices, the appellant was required to prepare a Kuisner International Check Request form in respect of the said invoices to be approved and signed by the Security Director, Mr. Rory Sanders, and Mr. Hanna. Once the check request was authorized by Mrs. Sanders and Hanna, the appellant was required to forward the approved check request with the corresponding invoice to the Atlanta's Accounts Department, where a check drawn on the account of KIBL will be prepared for the vendor. In this manner, the appellant was the last custodian of all authorized check requests before the same was sent to the Atlanta's Accounts Department. By virtue of her employment with the respondent, as aforesaid, the appellant owed the respondent a fiduciary duty to ensure that all vendors' invoices were submitted to Mr. Douglas Hanna for approval, and that only approved and authorized check requests in respect of the bona fide vendors' invoices were submitted to the Atlanta's Accounts Department for payment. So on the basis official, we are of the view that the duties of the appellant impose a fiduciary duty on her to act honestly and for the respondent. On her admission, the appellant abused this duty by 1, creating a false check request and fraudulent invoice in the name of Franklin Moss, and 2, enabling cashing the fraudulent checks, and 3, keeping the money for her own use. So you see how her fiduciary duty arise.
Yes, ma'am.
Yes.
And so now you have to think about in your own place of employment where person's job description depends on what they do, whether a fiduciary duty arise, because it doesn't arise automatically in the employment contract. It depends on the duties. So then our question was asked, was her summary dismissal justified? So we go to sections 31 and 32 of the Employment Act. And the list there. And the judge said, we agree the findings of the trial judge amounted to a fundamental breach of contract by the appellant. The circumstances in our view justify summary dismissal. So of course, she lost. At the end. Because she was claiming that it was done under duress, and it was not. There was no duress, none at all. And she was also denying that she had a fiduciary obligation, but she did. So summary dismissal may occur for the following reasons: disobedience of lawful and reasonable orders of the employer, which is in breach of the employee's duty to obey such orders. So go back to your nephew now.
All right.
Were the orders reasonable? Remember, that's why I asked you if there are other persons who have the same job description as he does. Have they been asked to do that same task in a similar situation?
Okay.
This is disobedience of lawful and reasonable orders of the employer, which is in breach of the employee's duty to obey such orders. So whether or not that order itself is something that he disobeyed, the disobedience must be willful and within the scope of the employee's duty under the contract of employment. And there's several cases here that you could look up.
Okay.
The second is misconduct, which interferes with and prejudices the safe and proper conduct of the employer's business. Negligence, and of course, incompetence. The test of misconduct in common law was outlined in the case of Carnival Leisure Industries for the Peter Zavosis, and I also put some other cases here. And then I left redundancy because I moved redundancy up. So you see, even looking at summary dismissal and his matters, there's a lot of things that have to be taken into consideration. Because you have to think about whether or not that order to clean those windows was reasonable. If the employer can come up and say that there have been instances where whoever is subcontracted to or outsourced to does it, and there have been occasions when it could not have been done. This was the situation on the ground. Persons in our employ who have the same job description have done it before. There are no special equipment needed. There were no instances needed. He had the opportunity to do it. He just blatantly said no.
Okay.
Then they will dismiss him.
Okay. Well, I know one thing. When any employee in mortgage corporation is asked to do something, they go to their job description. And trust me.
Yeah.
If it's not,
remember now. But
if it's
remember
not,
now, remember now, once you sign an employment contract, there are express and implied terms. And those implied terms are the ones you learned in the first half of the course. You have certain duties.
Right.
The duty, because it's contractual by nature. You have those express terms, but there are also implied terms. And those implied terms are those duties of loyalty, those duty to obey.
Yeah, but they didn't even, he just fired him. He didn't even give him a chance to explain probably why he was saying he's not going to do it, because he may not have been able to climb up on a ladder and whatever the case may be.
Right. So all of that has to be in his pleadings when he goes to the tribunal.
Understood.
Yes. All of that goes in there.
Okay.
All right. So we're done for the day. I am going to have to write something for those who communicate to, no, instead of telling me, why don't you just tell Ms. Dean if you wish to take the supplemental midterm, because I'm going to send it to her and let her deal with that.
Okay.
So you could advise Ms. Dean. I will send her a note to tell her that I'll be issuing a supplemental exam and the students who are interested will be contacting her.
All right.
Okay, and we could do it like that.
All right.
Okay, so for next week's class, you know, I will be sending you more cases and hopefully this time you will get to read it. Hopefully.
Yeah.
I read the Keva one.
I was just gonna say, I actually read Keva Brown and BAF.
Any questions, any comments? We're good?
Ms. Archer, is it possible that you can send the cases a little earlier?
I'll try.
Please.
And I sent you one to read, which would have been a part of the first half of the class. That's the one on overtime.
You sent one today?
No.
Okay, so I think we have 5 in total.
4 or 5, yeah.
Yes,
Stephanie.
Okay.
So you could read those on your own. Yeah, you probably have a bit. Okay, so I'll send you some more. I'll try.
Okay.
All right.
Thank you.
Thank you.
Because what I have
Great
to do,
weekend,
I have to make
everybody.
sure it's relevant.
Likewise.
And I tried. Okay, okay,
Yes.
all right. So let me send this
Okay.
that note now. So have a good
Okay.
afternoon and a great weekend.
Okay,
too.
you too.
After everybody.
All right.
Okay,
Bye.
Thank you. Good afternoon, everyone.
okay.